Commonwealth of Kentucky versus Michael Ash. And none of the transported people are here yet. Commonwealth versus Colton Randolph. Colton Randolph. Are you Colton Randolph?
Yes, sir.
We're on 24 CR 0087. You were born in 2006.
Yes,
Last 4 digits of your social security number 4446.
Yes, sir.
Okay, we're here today on a motion for release of records and pretrial conference. What's the Commonwealth have to say?
Well, we'd like to go ahead and enter the order so we can get the medical records from Scotland. Mr. Chair, that would point out. Then we've also tendered an order, I think they signed immediately this case, so we just set it back maybe on the August docket.
Yeah, that works for me.
Okay, we'll set it for August and the other orders have been submitted via electronically.
So
So
let's do that, Brandon.
Yeah, so I can do that.
you have the files, you got a new charge.
Oh, I see it.
No, I don't see.
Now, just see this delivery. And you can see this.
Okay, you have a agreement on a new charge here. The grand jury of, the grand jury of Clinton County has returned an indictment charging with possession of controlled substance of first degree methamphetamine, failure to maintain insurance, fleeing or evading police in the first degree, wanton endangerment in the first degree, 2 counts, operating a motor vehicle under the influence, and promoting contraband first degree. Do you understand what those charges are, sir?
Yes, sir.
Okay. You acknowledge the indictment might receive indictment, away formal legal arraignment, interplead not guilty, reserving all pre-trial motions.
Yes, sir.
Okay, now we'll go ahead and do the mediation order. And the motion, sign the order for release of medical records. We'll schedule an next appearance for July 10. You want a negotiation day between them?
No, Your Honor, we can have the August day. We've got an order to mediate the case, so.
August 7th. August 7th. Yeah, the other people, thank you.
Thank you.
Very much. You got
If we don't have to get a resolution, we'll get a trial date in August.
Okay.
As long as we got the medical records.
The other people from the jail are not here yet. Tyler Eminent. Tyler Eminent.
Your Honor, I believe he may be incarcerated right now in Adair County.
Well, what have you, he's here today for a pretrial. When have you talked to him?
It's been about a week, Your Honor.
Well, be good if you knew he's incarcerated, just tell us so we could have him transported.
I apologize.
James Armstrong. But Tyler Eminent, we'll put him off until July the 2nd,
Yes, we need him for the negotiation on June 30th at 9 also.
June 30th. And July 2nd. Combo versus James Armstrong, 24 CR 0013, 24 CR 0035 for sentencing. Have you had an opportunity, you are James Armstrong?
Yes,
Born in 1963, Is that correct?
Yes, sir.
Last four digits, social security number 8043.
Yes, sir.
You had opportunity to look at the pre-sentence investigation for probation and parole.
We have, Your Honor.
Is it substantially correct?
It is substantially correct.
Any reason why this gentleman should not be sentenced?
No, Your Honor.
Or plead guilty in indictment 24 CR 0035. Admitted charge of assault under extreme emotional disturbance. The defendant should receive 5 years, probated 5 years supervised. She received credit for time served 3 months and 10 days. Sentence for restitution $670. What's the court cost?
155.
155. So I'm gonna ask you to pay this. Does the restitution order say how much a month he's supposed to pay?
I don't believe we ever agreed on an amount. He's of course on fixed income, so we
Well, I
need to
know,
try
I'm
to
just
make.
asking. If it says, so I'm going, well, I'm paying $50 a month for the restitution and $25 a month toward the court. Okay.
75 total. I'll tell you.
Yeah.
You need to
I think
be a
it was $600
probation
some
parole
dollars.
officer. Now, what happened to 0013?
0013.
Yeah, down there on the plea agreement, it says that under indictment number 24 CR 0035, was 13 supposed to be included in the?
This was a superseding indictment, I believe.
It was. So it would be dismissed.
I see now it was dismissed and.
And the restitution's in the plea, and we did a restitution.
Oh, that's fine.
And just to, the restitution states that it was to be paid in full within 30 days of today.
Yes.
Okay. Well, we'll just get paid. Okay.
Thank you very much. I'm gonna meet with the probation parole officer. Probation parole officer. John Bombar. Fine. Commonwealth versus John Bombar. Is that how you say your last name?
Yes, sir.
Sir, you born in 1967.
Yes, sir.
Last four digits, social security number 5834.
Yes, sir.
You're here for a pretrial conference in 25 CR 0023. What's the Commonwealth have to say?
We have a pretrial diversion agreement, Your Honor.
Motion's been tendered, sir. It says you wish to approve of that. Is that correct?
Yes, sir.
Are you currently under the influence of drugs or alcohol?
No, sir.
You just plead freely and voluntarily given. Is this plea freely and voluntarily given?
Yes, sir.
Are you the same person that we just identified in the indictment? Are you the same person?
Yes, sir. I'm sorry.
Okay, is your judgment impaired today in any way?
No, sir.
Have you discussed this matter with your attorney and are you satisfied with his advice?
Yes, sir.
Have you reviewed the evidence the Commonwealth has against you? Do you believe you're fully informed about the case?
Yes, sir.
You understand that you do not have to enter a guilty plea. You have certain rights under the Kentucky and United States Constitution. Before I can accept the plea guilty, I need to know that you fully understand those rights. I'm
I
going to
do,
go
sir.
over them at the end. I'm going to ask you. You have a right not to testify against yourself. No one can make the same thing right to speed trial, but jury right to represent the counsel at your jury trial. Right to confront and cross-examine all witnesses, call testify against you, right to produce evidence, right to call witnesses in favor and have processes. You have a right to fill this matter to higher court if you lose, and right to require the Commonwealth to prove on a reasonable doubt that you are guilty of the charge against you. Understand that by entering a plea guilty, that you give up all those rights.
Yes, sir.
I may consider the Commonwealth's recommendation, but I'm in a plain range of central law. I don't have to accept the recommendation. In the event that I do not accept the recommendation, the Commonwealth has decided to impose a harsher sentence. You have the right to withdraw your plea and proceed to trial. You understand all that?
Yes, sir.
Now, I'm going to ask you some qualifying questions. Have you previously been diverted in the last 5 years?
No, sir.
Have you had any felonies in the last 10 years?
No,
Are
sir.
you currently on probation or pretrial diversion?
No, sir.
You understand that you do not fully, if you do not fully complete the diversion agreement, the charges, if you do successfully complete the diversion agreement, the charges will be dismissed pre-trial, or you have your record expunged. Understand? But if you don't successfully violate the diversion, you'll be brought back in front of me. If I avoid it, you'll be a convicted felon. You'll be sentenced according to the agreement. You understand that?
Yes, sir.
Mr. Stockton, are you presuming your Commonwealth's recommendation?
Your Honor.
Step with letter, so what is Commonwealth's?
If they want endangerment first degree, 2 counts, he'll receive a sentence of 2 years on each count, to run concurrently for 2 years, pretrial diverted for 2 years, supervised. He'll not be setting off any fireworks or creating a disturbance in the neighborhood. He'll obtain gainful employment, and all evidence in this case be destroyed.
So is that your understanding of the agreement?
Yes, sir.
Anyone, including your attorney, offering you any benefit for this guilty plea, or are you doing it voluntarily? Doing it voluntarily?
Yes, sir.
Yeah, you, of your own free will.
Yes, sir.
You know, your constitutional rights, as I've explained to you, it's still your desire to give up those rights, enter pleading guilty, and allow the court to fix your punishment as permitted by law. Is that correct?
Yes, sir.
Is that your signature on the document?
Yes, sir.
I'll accept the agreement and sign the division, or if you'll hand it over here. You'll need to do the probation pro officer, so you get information.
Thank you,
What's the
Ryan.
court cost about?
$155.
$155, you need some time to pay that?
Yes, sir. I got a monthly check.
I'll let you pay it $30 a month, first payment being 30 days.
Okay, thank you, sir.
Jason Craig. Caldwell versus Jason Craig, 25 CR 0020. Are you Jason Craig?
Yes, sir.
You born in 1978.
Yes,
So
sir.
that's 4 digits, social security number 7123. You're here for sentence. Have you seen the pre-sentence investigation report and the probation parole?
Yes, Your Honor.
Are you, is it substantially correct?
Yes,
The reason why this gentleman should not be sentenced.
No, Your Honor.
On plea of guilty to possession of controlled substance first degree, methamphetamine, defendant shall receive a sentence of 3 years. That's on plea for possession of controlled substance first degree, unidentified, the defendant shall receive 3 years. 2 3-year sentences, however, shall run concurrently for a total of 3 years. The defendant shall enter and complete the Clinton County Special Report. You shall receive credit for time served. Now, was there a DUI in this case?
yes, sir.
Did you plead guilty to DUI too? Stockton.
I'll have to look. Once, three.
Men operating motor vehicle with alcohol.
He should have.
Yeah, he's also guilty for an operating motor vehicle. And you realize that that's enhanceable too, right?
Yes, sir.
So we get another one. If you have this pre-trial diversion. Or you're on probation. Probation, so. Yeah, so if you have another felon, that could be legal, you understand that, right?
Yes, Your Honor.
Okay, what's total court cost?
Just $1,090.
$1,090 you'll be out, so you need some time to pay that.
Yes, sir.
So unless you pay it $60 a month,
Okay.
first payment will be 30 days. Okay?
Yes, sir.
Do we have a deed?
I thought I filled it out. We do not have it.
Well, just,
I don't know.
okay, we'll just go ahead and fill it out, take it, have it signed, fill it out again, okay? Matthew Crutchfield. Then we'll go to the jail docket, back to the jail. Come around here. Are you Matthew Crutchfield?
Yes, Your Honor.
You're on 25 CR 0033. You born in 1997,
Yes, Your Honor.
last 4 digits, social security number 0995. We're on a pretrial conference. What does the Commonwealth have to say?
We have a misdemeanor plea in this, Your Honor. The lab report came back marijuana and nothing else.
Your Honor, we still need to do the paperwork on that one, so can we come back to it?
Yeah.
Thank you.
Okay, I'm going back to jail. Michael Ash. Howell versus Michael Ash, 25 CR 0037. Are you Michael Ash?
Yes, sir.
You born in 1960? You born in 1960?
Yes, sir.
Last four digits, social security number 0684.
That's me.
We're here for a pretrial conference. What was the Commonwealth have to say?
Have a pretrial diversion plea, Your Honor.
A motion's been tendered, sir, that says you wish to enter a plea today. Is that correct?
Yes.
Are you currently under the influence of drugs or alcohol?
No, sir.
Is this plea freely and voluntarily given? Is this plea freely and voluntarily given?
Yes, sir.
Are you the same person that we just identified in 25 CR 0037?
Yes, sir.
Is your judgment impaired today?
Yes, sir.
Is your judgment impaired today? You know what?
Oh, no, sir. No, sir. I'm sorry. I'm hard of hearing. I'm sorry.
Is that better now?
Yeah.
Okay. Is your judgment impaired today?
No, sir.
Okay, have you discussed this matter with your attorney and are you satisfied with his advice?
Yes, I.
Have you
Yes,
viewed
sir.
the evidence the Commonwealth has against you, believe you're fully informed about your case? Have you reviewed
Yes.
the evidence?
Yes, sir.
You're fully informed about your case. You understand that you do not have to enter a guilty plea. In this case, you have certain rights under the Kentucky and United States Constitution. Before I can accept the plea, I need to know that you understand those rights. I'm gonna go over them with you at the end. I'm gonna ask if you understand, okay? You have a right not to testify against yourself. No one can make you say anything. Right to speedy trial by jury, right to be represented by counsel at your jury trial. You have a right to confront and cross-examine all witnesses called to testify against you. You have a right to produce evidence. You have a right to call witnesses and have process issues to compel their attendance. You have a right to appeal this matter at higher court if you lose, and a right to require the Commonwealth to prove beyond a reasonable doubt that you're guilty of charges against you. Understand that by entering a plea of guilty, you give up those rights. You understand that?
Yes, I do, Your Honor.
So, yeah, I may consider the Commonwealth's recommendation that I may apply any range of sentence provided by law. I don't have to accept the recommendation. In the event that I do not accept your recommendation, if I impose a harsher sentence, you have the right to withdraw your plea, go to trial. Do you understand that?
Yes, I
And I'm
do.
going to do some qualifying questions here. Have you previously been pretrial diverted in the last 5 years? Have you previously been pretrial diverted in the last 5
No,
years?
no, you haven't.
Have you had any felony convictions in the last 10 years? Are you currently on probation?
No, sir.
Do you understand if you can successfully complete the pretrial diversion, you have your case dismissed, pretrial diverted, you have your record expunged. However, if you don't successfully complete it, you're brought back from and I revoke your pretrial diversion. You'll be guilty of a felony and that can be used to enhance it in the future. You understand that?
Yes, I do, Your Honor.
If you'll step to your left, sir, Mr. Stockton, if you'll come up and tell us what the Commonwealth's position is.
Your Honor, Mr. Rice will plead guilty to possession of controlled substance, first degree, receive a sentence of 3 years, pretrial diverted for 5 years. He'll be assessed by the Social Service Commission, follow all recommendations. He'll receive credit for time served, obtain gainful employment or do community service work, and pay court costs at the discretion of the court.
Is that what you agreed to, sir? Is that what you agreed to?
Yes,
Okay, are you pleading guilty because you did commit the acts charged in the amended indictment? Is that true? You're pleading guilty because you did commit the acts charged in the amended indictment.
yes,
Okay. You're doing so of your own free will.
yes, Your
Have
Honor.
your constitutional rights to still your desire to enter the plea and allow the court to fix your punishment within the range permitted by law. Is that correct?
Yes,
Is
Your
that
Honor.
your signature on the document?
Yes,
Yeah, I accept the agreement and sign the diversion order. You want to give it to the bailiff here, and you gotta do that, and now you'll need to talk to the probation parole officer. Mr. Stockton, is it intent for him to be released today?
Yes, Your Honor.
Okay, you fill that out. The information. Frankie Davidson says he's in treatment. What does that mean?
That's a motion to forfeit guns and ammo.
He didn't file any objection to that?
No.
Okay, I'll go ahead and enter the order. Kelly Deacon.
Your Honor, this is another one I need just a little bit of time with Mr. Deacon.
He's gonna go over some paperwork with you. Anthony Garrett.
That's a motion to forfeit also, Your Honor. It's also handgun and ammunition.
So that case is a big grand jury.
It was that case, what it was bound over to the grand jury, so I think both courts have concurrent jurisdiction. It was bound over to the grand jury, but there was no indictment.
Did he plead guilty
What was on that?
in district court? Did he go back down to district court?
It was bound over, no indictment.
I don't see really how I can destroy anything if he doesn't have a plea or.
I'll tell the KSP to consult counsel. So I mean, really, we don't have any jurisdiction here.
I think that's true.
Yeah. They can go to district court. That was KSP. Yeah.
Derek Gary. Good morning. Commonwealth versus Derek Gearing, 25 CR 0015. Are you Derek Gearing? Yes, sir. Born in 1983. Yes, sir. Last four digits, social security number 3165. Was there a pretrial conference? What's coming?
Your Honor, we had a negotiation day, Mr. Poindexter raised the defense on the video, and my schedule, I've got to meet with the officer and, the detective, so we can go over this, if we can have one more pretrial. And
Do you want a negotiation day too?
Yes, June
June
30th.
the 30th for negotiation day and July the 2nd for the next court appearance, both of them conditions are brought. Okay,
Okay. June 30th and July 2nd.
that's correct.
Okay, thank you, Your Honor.
We didn't mind on it.
Yes.
You have a, you did. And Brandon Hall. Commonwealth versus Brandon Hall. Commonwealth versus Brandon Hall, 25 CR 0039. Let Mr. Hall stand by the podium. Are you Brandon Hall?
Yes, sir.
Born in 1982.
Yes, sir.
Last four digits, social security number 3773.
Yes.
We were unable to reach an agreement negotiation based on.
What's the charge?
It's trafficking in controlled substance, with the second offense, PFO second, it may be, it's a serious case.
You mind?
With the amount, it's already a city felony.
Yeah.
Can we just pass this for a few minutes?
We'll call him back. We'll pass over.
Just pass it.
Nicholas Kuba. Nicholas Kuba, is that how you said it last name? Nicholas Kuba. Commonwealth versus Nicholas Kuba, 25 CR 0034. Is that how you say your last name?
Yes, sir.
Okay. You born in 1988?
Yes,
Last four digits, social security number 8854. We're here for a pretrial conference. What's the Commonwealth have you stipulated?
I think Mr. Rutherford had it before it's coming in.
Yeah. Yeah, with this one, Your Honor, I would like to get one more negotiation day. He's facing.
Is that okay with you, Mr. Stockton?
It is, evidently has started in that.
The negotiation day on June the 30th and next court date here on July 2nd, both of them conditions of Mr. Kuba's bond. Tina Samson,
We just entered paperwork, Mr. Rutherford, we pass over her, so we go.
So we come back to, let's see.
Send it back to her for a plea.
They're gonna have to go over some paperwork for you. We'll call you back in just a minute, okay? Okay, let's go back to the regular docket then. Did I call Justin Graves previously? Justin Graves? Where is Justin Graves for arraignment? Issue a bench warrant without bond for Ms. Graves. Joshua Jones. Commonwealth versus Joshua Jones. 25 CR. 0031. Are you Joshua Jones?
Yes, Your Honor.
You born in 1997?
Yes.
Passport is social security number 7938.
Yes.
Representative Ms. King here. You're here for pre-trial conference. You all. What's the Commonwealth have to say?
We have a pretrial diversion plea.
Motion's been tendered, sir, that says you wish to enter pre-trial diversion. Is that correct? Are you currently under the influence of drugs or alcohol?
No.
Is this plea freely and voluntarily given?
Yes.
Are you the same person that we just identified in 25 CR 0031?
Yes.
Is your judgment impaired today?
No.
Are you satisfied with the advice of your attorney?
Yes.
Having to discuss this matter with her?
Yes.
And you view the evidence Commonwealth has against you, think you're fully informed about the case. You understand that you do not have to enter guilty plea today. You have certain rights under Kentucky and the United States Constitution. Before I can accept the plea, I need to know that you understand those rights. I'm gonna go over them at the end of it. I'm gonna ask that if you have any questions throughout the thing, you can step away and ask Ms. Keaton about it. Okay? You have a right not to testify against yourself. No one can make you say anything. Right to speed trial by jury. Right to be represented by counsel at your jury trial. Right to confront and cross-examine all witnesses called to testify against you. Right to produce evidence. Right to call witnesses in your favor. Right to feel this. Right to the high court if you lose. And right to require Commonwealth to prove that a reasonable doubt that you're guilty of the charge. You understand that by entering guilty plea today, you give up all those rights. You understand that? I may consider the Commonwealth's recommendation, but I may apply any range of sentence provided in the law. I don't have to in the case if I do not accept the recommendation, I will. Instead, give you a harsher sentence, you have a right to withdraw your plea and go to trial. You understand that? And have you previously been diverted in the last 5 years?
No.
Have you had any felonies in the past 10 years? Are you currently on probation?
No.
Do you understand that if you fully complete the diversion agreement, the charge will be dismissed, pre-trial diverted, and you can have your record expunged? However, if you do not successfully complete the diversion program, you'll be brought back in front of me. I can revoke the pretrial diversion. Ask for pre-sentence investigation report, schedule sentencing hearing, you'll be a convicted felon. Enhance the future, understand that? So you step to the left. Mr. Stockton, what is the Commonwealth's record?
Your Honor, he will plead guilty to trafficking in a controlled substance, first degree, first offense, receive a sentence of 5 years, pretrial diverted for 5 years. He'll complete the Wayne County Drug Court. My understanding is he's going in up there.
That is correct. He's
Okay.
currently in Spark and he's due to be released from Spark in July, and then he'll go into the drug court.
Okay, and that's a condition of our probation here. And he'll pay a $500 fine and cost. All controlled substances to be destroyed. And once he gets out into drug court, he'll be required to work.
Was there a driving charge in this too?
I really got a record scratch.
Yeah, it wouldn't do you out.
No.
Okay, well, is that what your agreement was? You need some time to pay this?
Yes, Your Honor.
What's the court cost?
Everything gave me is $655.
$655. I later paid it $75 a month. First payment being done in 30 days. And today, or you can pay it all anytime you want to, but at least $75 a month.
Okay.
Okay, are you entering this plea because you are guilty of the acts charged in the amended indictment?
Yep.
Okay, you your constitutional rights to sue yourself if you see you don't have me fix your punishment. Is that your signature on there?
Yes.
I'll accept the plea, and sign the diversion order. You need to meet with the probation and parole officer.
Jesse had not signed those.
Chesty, you want to come up and stop you? Sign those.
Judge, I want to make sure I understand. Did you say his first payment was due today?
30 days.
30 days.
Well, we'll
Okay.
take the money today, you know.
I just want to make sure we
Commonwealth
clarify.
running a little short.
Thank you, Judge.
Let me speak to you about something, bro. Is that I heard it. Don't. It's open.
He's not decided yet, but he's not gonna finish out his term. I think maybe next year.
Usually be on probation.
That's right.
That's your, yeah, we wanna have a retirement party or do something like that. No, yeah, he is. I think maybe
Probably
next
do
year.
that, put some flooring down. Thank you very much.
You're welcome.
Judge, that's all I have about these.
Absolutely. Michael Key. Caldwell versus Michael Key. 20 CR 0023. Y'all Michael Key, born 1980. Last four digits, social security number 2969. Mr. Cross here. It's pretty top.
It's the older case, Mr. King's been in Tennessee for quite some time. We needed a pretrial conference and negotiation day, June 30th at 9. And I need it where Mr. Cross and Mike can be there.
Let me be sure I can be there, Stockton.
June 30th and July 2nd. Those are both your dates, okay?
Bear with me. If we're not gonna be there, I wanna reset. Be there. Take one of that.
Caldwell versus Dennis Kempton.
He showed up in the arch.
Yes.
She's on the old church, that's right.
Yeah.
Well, raise your right hand. You solemnly swear affirm that you will faithfully consider all the matters that brought to or the grand jury in Clinton Circuit Court. And that you will faithfully execute the duties there and you keep everything confidential, protected as the Constitution of Colorado, protected the United States of America. Dennis Kempton, after worn out, says
We'll put him in CIC.
Kevin Lewis. Kevin Lewis,
Oh, Your Honor, he turned himself in as his, I think, yesterday or the day before. He's in Clinton County, but I do have paperwork for him. If we can, pick him up, to Clinton County docket.
This one was one where there was, he was originally for the law without. I guess it's.
hey, could you tell the jail to bring Kevin Lewis up here? Kevin Lewis. Jimmy Massingale. Caldwell versus Jimmy Massingale, 25 CR 0045. Are you Jimmy Massingale?
Yes, sir.
Good morning. You born in 1972? Yes. Last four digits, social security number 6814.
Yeah.
You're here for arraignment in 25 CR 0045. You have the right to remain silent. You're represented by Office of Public Advocacy, is that right?
Yes.
District Court. Continue that appointment. The grand jury of Clinton County is returning by charging you with terroristic threat in 5 counts. Menacing and being a persistent felony offender, 5 counts. Counsel, you acknowledge the identity of client received indictment, waive formal reading, arraignment, enter plea of not guilty, reserving all pretrial motions.
Yes, Your Honor.
Send a reciprocal discovery order. Just bring it all up. I'm gonna appoint you special bailiff here today. I'm signing a reciprocal discovery order here. I'll give you this information the Commonwealth has to help prepare for your case. It'll be a negotiation day at 9 a.m. on June the 30th. Your next court date is on July 2nd, 9 a.m. You continue down the same bond. Joseph McDermott. Okay.
I believe we.
He wants,
Let me go, we go.
yeah, we didn't know where these people are. I don't know what the deal is. But one came was online and we just released them.
We're supposed to have Megan Kennedy there, too, looks like.
Well, I was notified that she left for treatment this morning.
Oh.
Flags between county, because that would be that one email.
And I really don't understand them releasing her to the treatment when she's on the docket. I don't understand, so. So I guess somebody can try to see.
Honestly,
Yes.
see if you can get one penny back on.
Okay.
Well, did she make, Miss Candy make bond,
Joseph McDermott.
or did they just release her? That's my question.
Your Honor, it looks like Wayne County is.
Wayne County's back on now, okay. Okay, let's do Joseph McDermott. Joseph McDermott. We got a bad camera angle there. We take the camera up just a little bit. Wayne County, put your microphone on. There's a little microphone looking thing there. If anybody remembers when microphones look like that. The microphone is, the sound is not on. There you go.
Okay.
Are you Joseph McDermott?
Yes.
We're on for arraignment in 24 CR 0023, Mr. McDermott, 1985.
Yes.
Last four digits, social security number 5733. Okay, you need to
Yes.
raise the camera, either step back a little bit or raise the camera, either one, doesn't matter to me. How about sitting down in the chair? Oh, my God. Mr. McDermott. Yeah, well, Mr. McDermott, you done shot the fuse here.
Can you see me there?
Wait just a second, our electricity went off. Be calm here. Yeah.
So I'm still on the G.
Yeah.
We don't have any.
Yeah.
Like you're not forced.
So across the road too.
Not even go out like it did last time. This time it says clean the circuit on the screen. That's it. Their electricity went out together, so they maybe should load it.
Wayne County, do we have you back on there?
Yeah,
Okay. Okay, you'll sit down there, you'll take a seat there, maybe we can see you. You're Joseph McDermott,
yes,
going to take up 24 CR 0023 for the purpose of. When you represented in district court, the defender's office,
yes.
I'll continue that representation. Yeah, I'm gonna go ahead and assign you a public defender that I will reserve where we're gonna charge you. Well, you start to say something, sir.
I talked to pretrial services this morning and they said they was gonna appoint me a public defender, so I don't know if got that done yet.
I've got the form here that they do. They can recommend it. I make the decision. So
Okay.
you have some income and a job, so I'll probably charge you something later on, but it won't be that much, okay?
Okay.
There you go. The grand jury of Clinton County has returned an indictment charging you with theft by failure to make a required disposition, Class D felony. Counselor, you acknowledge the receipt of indictment, waive formal reading and arraignment, acknowledge the identity of the interplea not guilty, reserving all pretrial motions.
Yes, sir.
A negotiation date, June the 30th, court day on July 2nd, okay?
Thank you.
Your attorney will be able to speak to you. Now, was there someone else that we've been informed was there in the Wayne County Jail?
No, Megan Kennedy was, she left for treatment this morning, she may have gone back in the first week of June and
Okay,
So she had been held
Your
on.
Honor.
okay, well, I guess that finishes Wayne County then, okay?
there's drug court in Wayne County, she's going to treat.
Your Honor, I have a question for you.
You have an attorney here. What's your question? Go ahead.
And it's just regarding whether or not I'll be done with my charges in Wayne County this Monday. And I was wondering if maybe I can get an ankle monitor and back to a surety bond like my Clinton County thing was. So maybe I won't lose my job.
What I'm gonna do is have your attorney come over and meet with you today and go over the thing. He can contact Commonwealth attorney, and if they can reach agreement, I'll send a bond change, okay? Okay, thank you very much, Mr. Speaker. Thank you, Wayne County, for your cooperation.
All right, thank you.
I'll see you today.
Pollson, his bond has already changed, it's still showing sure, pre-trust.
Kevin Miller. Kevin Miller.
Yeah,
You take one off there. Kevin Miller, is Kevin Miller here? He's your bench warrant. Dale Pelis,
He's in Russell County.
Chesty Pollson. Kamala versus Chesty Pollson, 25 CR 0050. Are you Chesty Pollson?
Yes, sir.
You born in 1996?
Yes, sir.
Last 4 digits, social security number 4594.
Yes, sir.
You here today for the purpose of an arraignment. I'm sorry. Represented by counsel, you have the right to remain silent. The grand jury of Clinton County has returned an indictment charging you with operating vehicle under the influence, endangering the welfare of a minor, possession of drug paraphernalia, possession of controlled substance, unspecified, wanton endangerment of the first degree, and possession of controlled substance not in the original container. You understand those charges?
Yes, sir.
Yeah, I'm signing a reciprocal discovery order here that requires the Commonwealth to give you all the evidence of that verification. I'll set a negotiation date for the 30th. The next court appearance is on July the 2nd. Both of them are conditioned to your bond. You understand that?
Yes, sir.
Okay, thank you.
Your Honor, and I think she has, would like to ask the court to adjust one of the conditions of her bond, the curfew. If it's causing issues with your children, keeping up with them, is that?
You what now?
I was needing, I'm on a 24-hour bond right now. And, I have to pick him up from daycare. And on the restrictions that I'm on right now, I'm not able to do that. So I was wondering if I could get a couple of those changed.
And get your driver's license.
Yes, I was just doing, but I like, sometimes my parents can't pick up my kid, so I'll have someone to bring me to pick them up. But I'm not allowed to go pick them up. I'm not driving, no.
I have no objection to amended bond to allow her to have someone to drive her to pick her children up to daycare. And, you know, and doctor's appointments are for her children, so, I just, okay? Okay,
Thank you.
no problem. Austin Sekula,
Your Honor, he went into specialty court. We're withdrawing that motion.
is that Mr. Sekula?
It is.
Mr. Sekula,
Yes.
say that you've gone into specialty court so we can pass over your case, okay?
All right.
Nathan Stockton. Nathan Stockton. Commonwealth versus Nathan Stockton. 25 CR 0022. Are you Nathan Stockton?
All right.
You also have 25 CR 0036. What does the Commonwealth have to say?
Well, my understanding was Mr. Soam was representing Mr. and Ms. Stockton. And we resolved her case and he's withdrawn from this case.
So he's
My
asking,
understanding.
he's asking for a public defender to be assigned.
So I guess that's what I'm having.
You need to come up here and fill out an affidavit. Already for me, I should. Stacy Stockton. That's a companion case, Stacy
Yes.
Stockton. Where is she?
Hanging on one of his cases.
Where is she?
Well, we put her in order to dismiss. She paid a large amount of restitution and court costs, and I agreed to dismiss her portion of the case. So that was in accordance with the victim. She was here. Yes.
I saw the receipt.
Mr. Soam was up here and he tore up from missing jury duty. He said, "We're good to go." And I said, "Well, I'm going to tender an order to dismiss." I don't know if him and her just left or what. So I'm not requiring her to be here. Her case is complete.
Okay. Wesley Stockton.
Well, we didn't say nothing.
Yeah, he's the only one. See that.
Wesley Stockton. You know, I really don't have enough confidence in this docket now to issue a bench warrant. Now, I don't know where these people are. Some of them are here, some of them are there. I don't know, but I guess I will
Well,
find
I
out.
would say this on his behalf, we've had several pre-trials, and he's always been present, and he's always been at negotiation day. And we were needing one more negotiation day, so if we said it, if
I'll
he
set a
doesn't appear, I'll ask
negotiation
for
day
that.
on June the 30th and the next court appearance on the 2nd. You have a show cause here and also on the 2nd as to why he wasn't here. Richard Thompson. Commonwealth versus Richard Thompson, 25 CR 0029. Are you Richard Thompson?
Yes, sir.
You're represented by Mr. Poindexter. You're here on 25 CR 0029. Were you born in 1976?
Yes, sir.
Last four digits of social security number 1479.
Yes, sir.
What does the Commonwealth have to say?
I've asked for a trial date, and also, if he, also asked for, we got a motion to revoke bond.
Okay, let's hear that now.
I think Mr. Deputy Pendergrass, maybe in the grand jury, was contacted about that.
Look, it's come up here, Mr. Stockton. We can get you on camera here.
Oh, there's none. Okay, so Mr. Poindexter pointed out, says there's no curfew here on Mr. Thompson. If that's the case, then I wouldn't have a valid motion to revoke
There's
bond.
supposed to be one. Everybody's got a curfew on here. So if it's not on there, there will be from this point forward.
Okay,
So you go withdraw the motion.
I withdraw the motion. Evidently, the jail paperwork's not getting curfew on there. That's something's gonna have to be erased. Okay. Yeah, it's not your fault this time.
Is Jailer standing back here? We had Mr. Thompson's bond here, and whoever did the bond down there failed to put the curfew on it. So he's violated the curfew that we should have been on, but it's not on his bond, so I can't do anything about it. So make sure you tell your personnel that take bonds down there, put those curfew things on there, okay?
Yes, sir, I will.
No problem. Everybody has mishaps, no problem. Okay, the 30th, you want a trial date? What is this charge here?
Trafficking, I believe.
Yes, sir.
What's the amount?
38 grams, Your Honor.
See if I can- I'm not able to do that. My phone, I'm sure that I can off the trial.
Just.
Okay, let's look at the trial schedule here. You think this will be one? We have expert witnesses.
Well, I'll have to get one due to the amount, so I'll probably have somebody basic to testify. No, I'll tell them that.
Oh,
I can go down and notify you.
Sure, okay.
You want to, the week of starting July 7th appears to be fairly open. It's a couple weeks from now. Y'all open?
Yeah, that's fine.
July 7th and 8th, I'm open, Your Honor.
Okay, well, I think this is a one-day trial. So let's do it on the 8th.
And you want us here at 8:30?
Well, let's do it on the 9th.
Your Honor, on the 9th, I've got depositions in a case that's been out there for a while.
Let's do it on the 8th. Well, the 7th's on Monday. Did y'all go do it on Monday then Tuesday?
Doesn't matter, maybe we'll just have to make sure the lab person's available. We'll need to call before Mr. Poindexter leaves, make sure the lab person. So we
Okay.
check.
I'll go ahead and put a hold on that.
But he wants to, I can't want Amber, just call him and say that they.
It'll be the new jury's first case. Okay.
All right, thank you, Your Honor.
Yeah. Daniel Wright. Daniel Wright. Is Daniel Wright here?
There's not showing any service.
Okay, well, we'll just continue it to next week, set next month, subject to service. William York. Combo versus William York. 25 CR 0030 for sentencing. Are you William York?
Yes.
We're on 25 CR 0030. Are you born in 1984? Last four digits, social security number 0755.
Yeah.
You had an opportunity to look at the presets, investigation report, done by probation, parole. Will you turn the camera off on Independence House there? All right. Is the presets investigation report substantially correct?
Yes.
On a plea of guilty to flagrant unsupported, receive 5 years probate for 5 years. Defendant should pay monthly child support of $422 plus a monthly arrearage of $206 for a total of $620. Regular child support of $422 shall be due on May the 15th. June the 15th, and all subsequent payments in amount of $620.26 on August 15th. We do the same day each month. Have you made those two payments?
Yes.
For May and June, that you're supposed to?
Yes.
In the event the monthly child support is reduced, the monthly payment shall correspond with the adjusted downward situation. And you meet with the probation parole officer over there.
Thank you.
Now, what about Kelly Deacon? What do we do with Kelly Deacon?
I have paperwork for me to go.
So you got paperwork on Brandon Hall.
No. Let's Tina Samson and Kevin.
What about Brandon Hall?
We need to do one more pretrial on him. I talked.
Is he here? Brandon Hall? Cromwell versus Brandon Hall, 25 CR 0039. Mr. Hall said they need to do another negotiation day.
Correct.
On June 30th, and the next court date's July 2nd. So hopefully get your situation resolved. Okay, and then you got Tina Samson and
One, Mr. Rutherford needs to go and take it.
now what about Kevin Lewis?
Yeah, he's the last one, but Laura Jones is on the Russell County docket, but she's here today.
What about Kevin Lewis?
I have paperwork with him.
Okay, wait just a second. That's okay.
No, actually, no, yeah, I've had the paperwork finished with him. He just needs to be transported here. I'm sorry.
Where is Kevin Lewis?
He's back.
Yeah, you brought that.
Okay.
Steve out already.
You come over and call you. I told you wrong.
Kevin Lewis.
Okay, Kevin Lewis. Kevin Lewis. What?
I feel like I'm in district court here. I've never seen anything like it in my life. Not that our district judges don't do a good job, they just have a different burden. Like, we kind of expect people to be prepared, certainly, when they're doing these things. They always have.
I don't know if you signed it.
Are you Kevin Lewis?
Yes, sir.
Good morning. You're on 25 CR 0051. Mr. Lewis, were you born in 1995?
Yes, sir.
Last four digits, social security number 9640. We're here for the purpose of arraignment. You have a right to remain silent. You're represented by counsel. Yes.
All right, first, this is the wrong document.
Good. The grand jury of Clinton County is returned, you have a right to remain silent. The grand jury of Clinton County is returned on the indictment charging you with failure to maintain insurance on the motor vehicle. Possession of drug paraphernalia, possession of controlled substance, methamphetamine. Counsel, you acknowledge that you did, your client received indictment, wait formally, you're on an interplea not guilty or so, the all trial motion.
Yes, Your Honor, but we have a resolution.
It's a way. You've been indicted.
Yeah.
So they're pleading not guilty, now we're gonna let them go with all period.
Yeah, that was the one failure to communicate, but I'm gonna give you an opportunity to do that on that.
Is this a pretrial diversion or is it a felony?
Diversion, Your Honor.
Okay. Motion been tendered says you wish to enter a plea, is that correct?
Sure.
Are you currently under the influence of drugs or alcohol?
No, sir.
Is this plea freely and voluntarily given? Are you the same person that we just identified in the indictment?
Yes, sir.
Is your judgment impaired today in any way?
No, sir.
Have you discussed this matter with your attorney? Are you satisfied with his advice?
Yes, Your Honor.
Have you had plenty of time to review this matter, the matters as evidence in case you feel like you're fully informed? You understand that you do not have to enter a guilty plea today. You have certain rights under the Kentucky United States Constitution. Before I can set the plea, I need to know that you understand those rights. I'm gonna go over them at the end. I'll ask you if you know them, okay? You have a right not to testify against yourself. No one can make you say anything, right to speak trial, but you're right. Be represented by counsel at your jury trial, right to confront and cross-examine all witnesses, call testify against you, right to produce evidence, right to call witnesses in your favor. Right to fill this matter in higher court if you lose, right for the Commonwealth, so we have reasonable doubt that you are guilty of charge. You understand that by any this plea that you give up all those rights. I may consider the Commonwealth's recommendation when they apply 90 cents provide the law in the case I do not accept the recommendation and decide to impose a harsher sentence. You have a right to withdraw your plea and proceed to trial. You understand that? I'm gonna ask you some qualifying questions. Have you previously been diverted in the last 5 years?
No.
You have any felonies in the last 10 years?
No, sir.
Are currently in probation?
No, sir.
You understand that if you fully complete this version, probably the charges will be dismissed and can be directly expunged. You understand that?
Yes, sir.
But if you do not successfully complete the program, you come in front of me, I avoid your pretrial diversion, have a pre-sentence investigation report, done by probation and parole, and scheduled sentence. You'll be a convicted felon that can be used to enhance penalties in the future. You understand that?
Yes, sir.
Doctor, we come forward and tell us what the Commonwealth's recommendation is.
Your Honor, he would be really on possession of controlled substance first degree, have a sentence of 2 years, pretrial the verdict for 4 years. He would have to be evaluated by the SSC, follow all recommendations, obtain and maintain gainful employment, and pay court costs at discretion of the court.
What is support doc? 155. Is that what you agree to?
Yes, sir.
Are you pleading guilty because you did commit the act charged in the indictment?
Yes, sir.
Okay. Doing so of your own free will. Knowing your constitutional rights is your desire to allow the court to fix your punishment and the range permitted by law.
Yes, sir.
Set your signature on the motion that I offer.
It is.
I'll accept the agreement, sign the diversion order. Court costs again, what was your 155? You need some time to pay that.
Yes, sir.
You pay it $40 in 30 days and $40 every month you get paid.
I could probably pay it later.
You don't have to rush. I mean, always pay the cash and pass on the credit. He's not the Lord of this drug. Okay. Go right over there and see the probation program.
Your Honor, we also have Laura Jones here. I think she's in the Russell County.
But we hadn't gotten to the rest of it.
But she's present.
I know, but let me finish what we got first. You know, Dale Pelis is in Russell County, right?
Yes.
You do Nathan Stockton. Nathan Stockton. And is there anybody, you had Kelly Deacon, and Kelly Deacon. So the only one we got now is somebody you have here. Who is that?
Laura Jones.
Laura Jones, 25, felony, 0054. This is a rocket docket thing?
Yes, sir.
Commonwealth versus Laura Jones. What's the CR number gonna be on this? Yeah, we're gonna do it now. Closing. Yes, when do y'all give the CR? On the rocket docket, when do y'all give the CR numbers? This is the efficacy. Mr. Stockton, you know when they said, put on the rocket docket? When they, what is the
What's supposed
CR
to-
number?
How it's supposed to work is once we tender our offer to Mr. Rutherford and they accept and paperwork's executed, it's supposed to be turned in to the clerk's office. The clerk's office is supposed to put it on the docket
It's CR.
as a CR case. Yes, sir.
Well, we'll need, just pick, call over and find out what the next CR is. We can say. Are you Laura Jones?
Yes,
You were
sir.
born in 1991.
Yes, sir.
Last four digits, social security number 7626.
Yes, sir.
You're here for arraignment.
57.
57. 25 CR 0057. What's the Commonwealth gonna do in this case?
It's a 2-year pre-trial verdict for forward. This is the
Motion's been tendered, says you wish to enter a pretrial diversion, is that correct?
Yes.
Are you under the influence of drugs or alcohol?
No.
Is this plea freely and voluntary given?
Yes.
Are you some person that we just named in the indictment?
Yeah.
Is your judgment impaired today in any way?
No.
Discuss this matter with your attorney.
Yes.
Are you satisfied with his advice?
Yes.
Have you viewed the evidence Commonwealth has against you?
Yes.
You're fully informed about the case.
Yes.
You understand that you have certain rights under the Kentucky United States Constitution. You don't have to enter a guilty plea.
Yes.
I'm gonna go over those rights and end of it. I'm gonna ask you to understand. Okay? You have the right not to testify against yourself. No one can make you say anything. Right to speak your right, but you right to be represented by counsel at your jury trial. Right to confront and cross-examine all witnesses called to testify against you. Right to be evidence. Right to call witnesses in your favor. Right to appeal this matter in high court to the reason. Right to Commonwealth on a reasonable doubt that you guilty charge against you. Understand that by entering a plea today, you give up those rights. I may consider the Commonwealth's recommendation, but I may apply any sentence that's authorized by law. If I give you a harsher sentence, you got a right to withdraw your plea. Go to trial. I'm gonna ask you a couple of questions. Have you previously been diverted in the last 5 years?
No.
You have any felony convictions the last 10 years?
No.
Presently on probation or parole?
No.
Understand if you complete the diversion program, the charge will be dismissed pre-trial, whether you have your record expunged. You understand? You understand if you not complete the diversion program, it's reported to me, I bring them before the court. And revoke the pre-trial diversion schedule sentencing, and you'll be a convicted felon that can be used against you in the future. You understand that?
Yes.
You come forward, Mr. Stockton, step to the left.
Yes, Ms. Jones will plead guilty to possession of a controlled substance, first degree, receive a sentence of 2 years, pretrial diversion for 4 years. She'll be evaluated with SSC, follow all recommendations. She will also obtain and maintain gainful employment, pay court costs of discretion.
What's full cost?
155.
$155, you pay that at $30 a month, okay?
Okay.
Is this what you're agreed to here?
Yes.
You know, your constitutional rights explained still your desire to proceed and enter plea of guilty and charges of the court to fix your punishment. Is that your signature on the motion and offer?
Yes.
Accept the agreement, sign, I'll sign the pretrial diversion order and you can meet with the probation control officer, okay? Okay, now we have anybody that's on the out of custody or transported docket, we hadn't addressed.
Yes, Your Honor. Brett Carver should have been on the out of custody docket.
Jonathan Landon for Mr. Carver. Judge, you had asked that
submit a motion to dismiss by today. I had trouble filing that. I do have a hard copy. I'll give the clerk the copy as well. I want to give Ms. Stockton opportunity to review and respond.
Yes, Your Honor. We'll need another pretrial conference date. I'm sitting here contemplating this. I think July 2nd is going to be too soon for me to respond to this. And I will not be present in court on August 7th. So I don't know if we want to set this in September or get some of my staff to handle this.
Yeah, I don't want to go out to September, but I understand everybody's got conflict.
I'll just use as much time as Mr. Lemons had to prepare the motion. I may need as much time to respond.
I have no objection.
But no, anytime I left, when I was practicing, anytime I left court with my client free, I felt like it was a small victory. This will keep.
Because I will have to get with Detective Duber and go over the previous case and this case. This won't be a short motion to respond to. And this week, I know I'm actually preparing for the O'Donnell murder trial set in October because I've got 80 witnesses on that case. And half of them are out of state, so I'm kind of tied down. So if you don't want to go to September, I'll just let somebody else.
I don't know that we don't want to go to September. That's a decision that you can make.
Well, I think there's a complexity in this case. I
Yeah.
think September would be appropriate.
I'll
That's
tell you
all
what,
right.
I'll tell you what, let's
think-
do. Let's set it.
Deadlines, that's fine.
Never mind. Let's set it in September. September the 11th. Okay, does that finish everybody that Mr. Stockton got out of?
I think so. Exception please, we got.
Let's Tina Samson, she's been brought out like 3 times. Yeah. Where's the lady on the docket? There she is up here. Yes, Tina Samson. I know that's a different mistake, but she's. Okay, what about Nathan Stockton? Stockton, I'll appoint you a public advocate here. Yeah, I'll go ahead and appoint you a public advocate. I'll reserve the later whether you get charged.
I need to stay here.
Yeah. Be good. Everybody else doing what they want to today, might as well get right. Okay, okay, where are we at on Mr. Stockton here? Is it arraignment or what?
This would be a pretrial conference. I think he's been arraigned on both of his cases.
So he's got a new attorney, so we probably need to have a negotiation day on June the 30th, next court date on July the 2nd. Okay. Okay, now that finishes that, the transported out of custody docket here. Except for us, Tina Samson, who's doing the paperwork on her?
I have the paperwork. You want me to do it now?
Well, I mean, yeah,
Well, I mean, I just don't want. to
yeah,
see all-
okay, well, let's take a break here for a second. And then we'll go right to Russell County. Go ahead and do her paperwork, and I'll take a quick break. Fifth, Cody Smith. Commonwealth versus Cody Smith, 23 CR 0067. Are you Cody Smith?
Yes.
Are you born in 1992? Last four digits, social security number 4267. You're here today for sentencing, represented by Mr. Poindexter. You had an opportunity to look at the precinct's investigation before we done a probation parole. It's substantially correct. Mr. Poindexter, is the reason this gentleman should not be sentenced?
No, Your Honor.
Commonwealth recommends 2 5-year sentences running consecutively for 10 years, served 90 days in jail, balance, pre-balance. This is a misprint.
No, it's John version of conventions. So you don't have to put it.
So this was a revocation.
Yes, Your Honor.
So you'll receive 10 years, correct?
Yes, sir.
I'll waive the court costs considering length of the sentence.
Can we address probation, Your Honor?
Yes.
Your Honor, we had submitted a letter from a proposed employer and also from the victim in the case. Those are the originals with signatures. I think the ones that we submitted did not have signatures. I believe it's I believe it carries great weight that the victim in this case is here today and has submitted an extensive letter asking for leniency. She is the mother of his children. She states in her letter that when he was on drugs and had a drug problem, he was a bad person, but that when he got straightened out through drug court, between December and April of this year, his complete personality changed.
He got kicked out of drug court.
He got kicked out of drug court, Your Honor, for his first penalty, which seemed odd to me that there were no
Okay, well,
graduated sanctions.
I'll take this under consideration with a motion for shock probation.
Yes, sir.
Okay, you get ready for shock probation. I'll take this under and then that way the Commonwealth have an opportunity to compare and take a look and see how he's done between then, okay?
Yes, sir.
I'll let you have these originals back.
Okay.
Okay, thank you very much.
Hey, Steve.
We're finished with the Wayne County. We didn't make it. She's the guy. She got to go there. Yeah.
She's on there.
She is on there now. Commonwealth versus Megan Kennedy. Who represents Megan Kennedy? Mr. Stockton?
Yes.
Commonwealth versus Megan Kennedy. No, but she represented by public advocate. Did you get the public defender to come out here? Is he back there? Megan Kennedy is on the line here for the purpose of arraignment. Ms. Kennedy, you were born in 1991.
Yes, sir.
What are the last four digits of your social security number?
1034.
Okay, the grand jury of Clinton County has returned an indictment charging you with possession of controlled substance of first degree methamphetamine, possession of drug paraphernalia, and possession of drugs not in the original container. Counselor, you acknowledge the identity of your client, received indictment, waive formal reading arraignment, enter plea not guilty, reserving all pre-trial motions.
Yes, Your Honor.
Now, why is Miss Kennedy, where is she and why is she there?
She's out on our bond. And Wayne County released her. They have had a drug court holder and sent her to treatment. It's my understanding. Is that correct?
So that's the reason she left Wayne County Jail, drug court, and Wayne County released her to go to treatment. She's in compliance with our bond.
Okay. The negotiation day on June the 30th at 9 AM, and the next court date is July 2nd. And if you're still in treatment by then, you need to make arrangements to have somebody transport you here. You understand what I'm saying?
Yes, sir.
Okay, thank you very much.
Thank you.
Now, are we ready to go to, have you got that person back there ready yet?
Not yet.
Well, how much longer do you think it's gonna be? It's a pretty simple document, isn't it?
Just a couple of minutes.
Okay. Russell County will be with you in just a couple of minutes. Sorry.
We've also got Matthew Crutchfield, too, on the laptop, if it's that voice taken out.
Yeah, I would have been.
We thought him, but it's a misdemeanor, well, you can see he didn't have the paperwork signed out.
Yeah, let's go off the record. Commonwealth versus Tina Samson. Third time charge. Commonwealth versus Miss Tina Samson. 25 CR 042. Are you Miss Sampson? Born in 1969?
Yes, sir.
Last 4 digits, social security number. 8714. You're here for pre-trial conference. What do you have? Stockton.
Felony quote.
A motion's been tendered, ma'am, and said introduced to enter plea today. Is that correct?
Yes, sir.
Are you currently under the influence of drugs or alcohol?
Absolutely not, sir.
Are you the same person that we just named in the indictment?
Yes, sir.
Is your judgment impaired today in any way?
No, sir.
Can you discuss these charges with the attorney? Are you satisfied with his advice?
Mm,
And you
I've
read the
discussed them
evidence
with
the Commonwealth has against you and you feel like you're fully informed about your case?
Yeah.
You understand that you do not have to enter a guilty plea today. You have certain rights under the Kentucky of the United States Constitution. Before I can accept a plea guilty, I need to know that you fully understand those rights. You have a right to not testify against yourself. No one can make you say anything. Right to speak trial for jury, right to be represented by counsel at your jury trial. Right to go to cross examine all witnesses called testify against your right to be seven, right to call witnesses in your favor. And the right to appeal this matter to higher court if you lose. You have a right to require the Commonwealth to prove beyond a reasonable doubt that you are guilty of charges against you. Understand? You guilty plea doesn't give up those rights. Understand that?
Yep.
Okay, I may consider Commonwealth's recommendation, but I may apply a range of sentence provided. Well, I don't have to accept the recommendation. Prior to accepting the recommendation, I will order a pre-sentence investigation report for probation and parole. After reviewing that, I decided to not to accept Commonwealth's recommendation, decided to impose a harsher sentence. You have a right to withdraw your plea of guilty at that time and go to trial. Okay, Mr. Stockton, you come forward with the Commonwealth's recommendation.
Yes, Ms. Sampson will plead guilty to trafficking and controlled substance first degree, 3 counts, receive 5 years on each count for a total of, can run concurrently for a total of 5 years, serve 120 days in jail with a balanced probate for 5 years supervised. She'll receive credit for any time served, and all evidence in this case will be destroyed.
Is that your understanding of Commonwealth's recommendation?
Yes, sir.
Are you pleading guilty because you did commit the acts charged in the indictment as amended? Doing so of your own free will?
Yeah.
Knowing your constitutional rights extended to still your desire to give up those rights, allow the court to fix your punishment of the language committed by law. You realize that any future conviction will be enhanced with persistent felony offender law. You understand that?
Yes, sir.
Okay. Is that your signature on the document?
Yes, sir.
I will accept the agreement order pre-sentence investigation report and schedule sentencing on July 2nd. How many days does she have in?
61.
So you'll have it done, quite a bit of it done by then when you come back. Okay. Thank you very much. Okay, you got a misdemeanor plea?
Yes, yeah, Matthew Crutchfield.
What's this gentleman's name?
Matthew Crutchfield.
Caldwell versus Matthew Crutchfield, 25 CR 0033. You are Matthew Crutchfield, born 1997, last 4 digits of social security, 0195. Is that correct?
Yes, sir.
I understand that there was a misdemeanor plea. Is that right, Mr. Stockton? Can you go ahead and read what the offer is?
Yes, it would be 2 years on possession of marijuana, supervised, 12 months probated for 2 years, supervised, pay a $200 fine and cost, receive credit for any time served, but maintain and maintain gainful employment, and pay court costs discretion of the court.
Is that what you agreed to? Should we go behind the microphone all the time?
Yes, sir.
Okay. Are you currently under the influence of drug or alcohol? Or is it freely involved in the game? It's freely involved in this plea, freely involved in the game for 2 years. You have plenty of time to talk about the scenario you returned. Yes, sir. Satisfied with his advice. So you need the evidence come up as against you feel like you fully understand the case.
Yes, sir.
You understand that you're not having to guilty, but that you have certain rights under the Kentucky United States Constitution, Part 6. You have right not testify against your own, you make the same thing, right to speak trial, the jury, like the representative counsel, to jury trial, right to Thompson, and all witnesses call testify against your right to use the evidence, kind of law. Right to call witnesses in favor, right to go as a matter of higher court to lose. Right to have a problem with the reason that you have a choice against you, understand that by entering guilty, you have against your trial. Yeah, I may consider Commonwealth's recommendations just for, I make a lot of things for sentence, so this is the maximum sentence allowed, but I could deny you probation. If I do that, you realize you can withdraw your plea, right? Are you pleading guilty because you didn't commit the acts charged? That is true or not? It's true. Okay. Okay, you know your constitutional rights, still your desire to give up those rights and never plead guilty and allow the court to fix your punishment. Correct? Is that right?
Yes, sir.
Okay, so we've got a voice activated.
So.
It's okay. Is that your signature on the motion and offer?
Yes, sir.
Okay, I'll accept it, sign the order here. What's it?
Total $355.
It's gonna give you anything. $355, you need some time to pay that.
Yes, sir.
Okay, let's pay $35 a month, first pay in 30 days from the day you meet with probation and parole officer. Now, Russell County, you ready for me? Sorry, we're a little later than usual.
We also have Kelly Deacon, didn't it doesn't mean time.
Oh, we did again, did.
One. Yeah, that was two.
Got Kelly Deacon.
Earlier.
Almo versus Kelly Deacon. And then Rain Dennis.
This is a rocket docket case.
Still gotta be Rain.
The 25
25 CR 0056. This is gonna be charged with possession first degree, is that correct?
That's
Yes.
correct.
Mr. Deacon, what's your year of birth?
11/8/73,
Last four digits, social security.
80/59.
Yeah, I understand that you wish to enter a felony plea today, is that correct?
It's pretrial diversion.
Motion is sets that you wish to enter a plea today, is that correct? Are you currently an influence drug or alcohol?
No.
Is this plea free and voluntarily given?
Yes.
Are you the same person that this was arraigned?
Yes.
Okay. Is your judgment impaired in any way today?
No, sir.
Discuss this matter with your attorney. Are you satisfied with the advice?
Yes.
Review the evidence Commonwealth has against you.
Yes.
Are you fully informed about your case?
Yes.
You understand that you do not have to enter guilty plea, that you have certain rights under the Kentucky United States Constitution, what I accept. I need to know that you understand those rights.
Yes, sir.
You're right not to testify against yourself, no one can make the same thing, right, so you file the jury, represent the counsel, file that. That's process, and all witness call testify against you. You say what's right, call witnesses, for failure right to Pelis, no matter how court you lose, right to part of the Commonwealth, for no reason without that you're going to say. You understand that even you give up all its rights. And we consider Commonwealth's recommendation, but I think that brings sense. Well, I don't have to accept the recommendation. In the event I don't accept the recommendation, decide that both the hardest extent, you're right to withdraw and put in those trials.
Yes.
You understand that?
Yes, sir.
Now, have you previously been converted in the last 5 years? Have you felony convictions the last 10 years?
No, sir.
Are you on parole?
No, sir.
You understand that if you fully complete the diversion agreement that you reach, the charges will be dismissed, and you have directly expunged. You understand that?
Yes.
However, if you violate the terms of pretrial diversion, you can be brought back in front of the court and scheduled sentencing hearing after voiding your pretrial diversion. You would be a convicted felon that could be used against you in the future. You understand that?
So,
If it's not, you come around and you tell us what Commonwealth's recommendation is.
Yes, Your Honor, Mr. Deacon will plead guilty to possession of controlled substance first degree, receive a sentence of 2 years, pretrial diverted for 4 years. He will receive credit for time served. He will be referred to the Social Service Commission, follow all recommendations. He'll obtain and maintain gainful employment. All evidence be destroyed, and he'll pay court costs at discretion of the court.
$155. You should have to pay that.
Do what?
Yeah.
Yeah.
Pay $25 a month. You pleading guilty because you did commit the acts. Are you pleading guilty because you did commit the acts? It's charged in the amendment of that.
Yes.
It's not your constitutional rights. It's still your desire to go here and give up those rights, allow me to fix your punishment. Is that your signature?
Yes, sir.
I'll accept the pretrial diversion agreement, sign the order today, make your first payment or you're fine within 30 days. Get your probation parole officer, okay? Okay, Russell County, Virginia, Connor.
You got anything?
Go ahead and speak to him.
Yes.
Your attorney Shelby Crawford is not on the line yet, so that was your case.
I saw her on there earlier.
She was on there earlier, emailed me that she has low cell-phone and internet reception on the drive on, but she didn't mind passing.
Did you say she has to pass it?
She said she didn't mind passing if she couldn't get back on.
Well, she wasn't moving around, she could. We'll come back to the end of the docket. Can somebody try to get a hold of her?
Thank you.
We'll get back to Justin Davis.
He's in prison, Your Honor.
He's where?
He's in prison, Judge Williams. They sent him to prison. They sent him to prison a couple of weeks ago.
Well, okay. I guess we'll just schedule a pretrial conference and notify him. You know where they sent him, Mr. Jailer?
I can find out for you.
Okay, probation.
Yeah, we seen the road
Rotor,
in the
okay.
range.
Okay, we'll schedule him for next month, July the 2nd. Commonwealth versus Deacon. How do you say your name there?
Chiquisha.
Keisha, well, I bet that's hard to run that cell when you're a first grade one.
Yes, sir.
Okay, we're here today, 24 CR 0052 on probation revocation. What's the comment? That's
Your Honor, this is our motion to revoke probation. She has a 3-year sentence on possession of controlled substance. Basically, Mr. Payne tried to transfer to Ohio for supervision. That was rejected. After that was rejected, she absconded and failed to attend treatment. I've talked with Mr. Rutherford. If she wants to do drug court here in Clinton County, I'll offer it to her if it's all right with the court. If not, I'll ask she stand revoked.
Yes. She's okay with it. She did ask if you would consider long-term rehabilitation.
No,
so
it's either drug court or
She would accept her.
Okay, well, I'll do the drug court referral. They'll go over and interview her, and it'll take a little while to get it set up. Somebody will be over to interview you, and I'll have to buy it probably next time they meet, it's July the 2nd. Okay, so they'll be in contact with you. This drug court, you need to be ready to do this drug court. If you're not willing to do it, you just need to go ahead and go rope the cat and go ahead and get your time behind you, okay? So you want to try to? Okay. Ashley McCuster.
Yes,
Are you Ashley McCuster?
yes,
Okay, we're on 24 CR 0048. Were you born in 1987?
yes,
Last 4 digits, social security number 4575.
yes,
Here today for sentencing, you had an opportunity to look at the pre-sentence investigation report by probation and parole.
yes,
Substantially correct.
yes,
Okay, you are sentenced to 2.5 years on each of the 2 counts. To run consecutively for 5 years. It was pretrial diverted. And on May 2025, the pretrial diversion was voided. So you're sentenced to 5 years. I'll waive the court costs since you're going up, okay?
okay.
Thank you. James Guffy. Commonwealth versus James Guffy, 25 CR 0032. James Guffy,
Yes, sir.
born in 1971.
Yes, sir.
4 digits of social security number 8258.
Yes, sir.
You're here today on a pretrial conference. What do we have, Mr.
We have a pre-trial version.
Okay.
It hasn't been signed yet. I was hoping maybe the board could fax it to him to sign. I have discussed it with him.
To the jail, they're gonna fax him his paperwork over there now, okay? And we'll let him look at it and sign it. Mr. Governor, the paperwork's on the way over there, okay?
Thank you.
Kathy Phillips. Kathy Phillips. Are you Kathy
Yes, Your Honor.
Phillips? This is 23 CR 0003. Born in 1979. Last 4 digits, social security number 6652, is that correct? It
Yes,
Says
sir.
pretrial diversion revocation, what's the comment on that to say?
Well, he has possession since 3 years.
Since she's been on, been supervised, she's had 3 positives for meth and 4 marijuanas. I think she'd be a good candidate for drug court if she wants to go in court approval.
And she agrees to that. I've discussed it with her.
You gonna try drug court, Ms. Phillips?
Yes, Your Honor.
You had a pretty bleak record up to now staying off the stuff. I know it's not easy. But, you know, I'll go ahead and sign the order referring you there. They'll do an evaluation, try to vote you in. And if you get in, I'll sign
Thank
it
you.
when the orientation is, okay?
Thank you, sir.
Good luck to you. Taylor Phillips. Are you Taylor Phillips?
Yes,
You born in 1997.
yes,
Last 4 digits, social security number 5260. You're on
Yes.
21 CR 0042, a pretrial diversion notification. What do you got, Mr. Doc?
Let's see, she graduated from drug court on November 18th of 2024. She was positive for meth on January 2nd and May the 20th of 2025. She was supposed to go to CDI and she's advised probation parole, she's pregnant. So I think Mr. Rutherford said he had a place to put her where she's pregnant,
Yeah, I can find her.
or the court can revoke her. That's where we are.
How much time does she have on the shelf?
We got 5 years on receiving a stolen property.
Of course, that was 4 years ago too, wasn't it?
Yeah, so she's been at this for a long time. She's been in drug court for 2 years, I think.
And then she evidently it didn't take. So I don't know. The only
Did she
reason
graduate from drug court?
she graduated in November. Only reason I was gonna show her some leniency, if she is in fact pregnant, I hate for to have her baby in prison. But maybe that's where
What kind of place do you have?
I mean, I have multiple locations I can find for. her. I have a contact.
Well, you can get a place and present it to Mr. Stockton. And Ms. Phillips, I know you wouldn't intentionally, I don't think you would intentionally hurt your baby.
no,
Okay, but you know, this, you got more to think about now than just whether you want to get high or not. You know what I'm saying?
yes, sir.
We're gonna try to find a rehab somewhere. How far along are you in Logan?
3 months,
How much?
3 months.
That's what I'm. Let's try, see how she goes, and it's a sad thing for babies to be born in penitentiary, because a lot of times they're born and they take them away from you right then. Sometimes they don't even get to hold them just for a second. I don't want that. I don't want that to happen to your baby. I don't want it to happen to you. We're gonna try to find some place to put you here. And I hope that you get some cooperation. Let's see if we can have her someplace for the duration, you know what I mean?
Yes.
Okay, thank you very much.
All right, thank you.
You gonna work on that since.
Stephanie Prater. Commonwealth versus Stephanie Prater. 24 CR 0092. Are you Stephanie Prater?
Yes,
1999.
yes,
Last 4 digits of social security number 2280. What do you have, Mr. Stockton, on pre-trial diversion revocation?
Your Honor, she was a rocket
Yeah, come
docket.
around and get on the conference.
She was a rocket docket. She had a 2-year sentence, and she absconded from I think Heather Elders was supervising her. I don't know, do you live out of the county, Miss Prater?
Right now, I don't live anywhere.
I think if she wanted to do drug court, she'd be a good candidate, try to get her life straightened out.
If I put you in drug court, you have a location in Kentucky you can live at or in Clinton County,
Yes,
where would that be without giving them an address? Who would it be with?
Tara Ayers.
Y'all understand what she's saying?
Terrors, what she said.
Is that okay?
That's fine. If she wants to try that out, we'll see how. it
Okay,
goes.
well,
Mr. Cross concession.
We'll do it. Well, I'll order you to drug court, give you an opportunity to work your way out of this thing, okay? And,
Okay.
we're doing an assessment. I'll sign the order for an orientation. This is kind of it. Well, you know, if you don't make it through this, you know, you could take a ride to the big house. You understand what I'm saying?
Yes, sir.
Okay, thank you. Mickey Shelton. Mickey Shelton. Are you Mickey Shelton?
Yes, sir.
24 CR 0085. Were you born in 1970, Mr. Shelton?
Yes, sir.
What is it? Social Security number 7583. We're here for a pretrial conference. What we have?
I guess, Your Honor, if we can set him for one more pretrial and a negotiation, and if we can't resolve the remainder of his case, we can get another trial date. Yeah.
30th for a negotiation. We'll do, make sure we get a transfer order in the next court date, July 2nd. Thank you. Ginger Smith. Ginger Smith.
Yes, sir.
Commonwealth versus Ginger Smith. 24 CR 0083. Miss Smith, you were born in 2001. Is that correct?
Yes, sir.
What are the last 4 digits of your social security number?
3992.
3592. Is that what you said?
3992.
3992. Okay, thank you very much.
Yes, sir.
Here on a pretrial diversion or revocation was a comment that still exists.
She also came in court on the rocket docket. She had a 2-year sentence on possession. I don't know what to do other than revoke Miss Smith. She's had 3 positive tests for methamphetamine, 1 for THC. She was terminated from IOP due to use of meth, sent to inpatient treatment and left treatment, was directed to report to office. She failed to report. I don't know. Doesn't sound like she wants to cooperate out.
I believe she didn't turn herself in,
15 days after she left treatment.
again, I would just ask for either long-term.
That's better than going to Alaska.
Yeah,
I don't know. Does she have stable housing here in Clinton County?
Yes, sir, I do. Corey was supposed to talk to y'all about drug court.
the drug court is the other thing.
Well, you just kind of like getting on without to turn yourself in, so we haven't talked about it much. I'm willing to try her in drug court, but if she runs off, she's not gonna last long.
You understand that you got 1 foot in the penitentiary, don't you, right now? You understand that? We'll do a assessment for drug court.
Thank you, sir.
If you don't make it in drug court, if you slip up, I don't want you to come back up here and ask for anything else, because this is your break here, okay? So we'll have you
Yes, sir.
assessed. You still, how old are you? You said you're born in 2000.
I'm
24
23 years old.
You know,
Fixing to turn 24.
you got plenty of time to turn yourself around and have a really great life out there, if you will, or you can fool with us for a long time and go to the penitentiary. And I know I'm a very pleasant person, but I'm sure you'd really like dealing with it right now, correct? You know? Okay, well, we'll have somebody over and interview, okay?
All right, thank you, sir.
Okay, let's see who else we have there that we haven't dealt with in Russell County. We had some paperwork sent over. Is that Mr. Guffy?
Yes, Your Honor, Mr. Guffy just got the paperwork. He's looking over it right now.
You have anybody else we haven't seen there?
Virginia Connor's still here. We'll wait for her attorney to appear.
No, that's right.
We don't have her cell number. We can't find it.
Dale Perelis, you have Dale Perelis there?
I do. We can get him for you, Your Honor.
Okay, that'd be great. All right. Worry about it.
Virginia. Welcome to
Dale Perelis. Come up there. Howell versus Dale Perelis. Twenty-four CR 0094. Are you Dale Perelis?
Yes, sir.
Born in 1962.
Yes, sir.
Last four digits of your social security number 9360.
Yes, sir.
Have you had an opportunity to review the pre-sentence investigation report done by Probation Parole?
Yes.
And have you also looked at the comprehensive sex offender pre-sentence evaluation? Have you looked at that also?
Yes.
Okay, is there any reason this gentleman should not be sentenced today?
I think there might be one issue as far as.
Go ahead.
We've got his duty to register, that his attorney has to go over with him, he has to sign.
I'm sorry, I was unaware of that, Your Honor. I'll go over that with him.
Well, I'll go ahead and do the sentencing. When are you going to Russell County?
I can do it today.
You can read it to him on record, send it over there and let him sign it if you're okay with that.
I'm okay with that.
Okay.
You have a requirement to sign a duty to register. If I send it over there, are you in agreement to sign that?
Yes.
Yeah, I'll go ahead and sign it. Dave's here. We'll send it over there to the jail and so that's on the way over there. The Commonwealth recommends that sentence rank consecutively for a 12 years to serve, no contact, or guilty plea. Is that correct? I'll waive the court costs. This is in 24/00/94. Is that correct, Mr. Stockton?
Yes, John.
Okay. They'll have that over there, and I guess you need to go over and interview him too. He's not gonna be probated. This will be just.
He's already had his PSI.
Okay. Okay, thank you very much.
Thank you, sir.
I'm waiving the court call. That's a lengthy sentence. Now we got Virginia Connor, is that correct? Virginia Connor.
Your Honor, this paperwork back over to you all real fast on Mr. Guffy.
Yeah. You'll send it back over. It'll be good.
Will you also please fax the paper on Mr. Perales?
On who?
They haven't got it on Mr. Prowse yet.
I just faxed the paper on Mr. Perales. Will you fax it back to the clerk's office?
Yes.
We just now seen it.
Okay, wait a second. Wait a second. Let's do one thing at a time here. Let's don't get any more confusion going on. Although today, we might as well get all of our confusion out of the way today. Because next month, we're not gonna have confusion. You're gonna have all your papers signed. Are you gonna be here next month?
Yes.
That'd be good. Well, I just asked because the clerk's not here and one of our bailiffs is not here. One of our attorneys didn't show up.
Maybe we need to start having ghosts.
Makes a person wonder, doesn't it, Mr. Stockton? Virginia Connor.
Yes,
We don't have your attorney here. What was gonna happen with Virginia?
It's a sentencing and our office doesn't have her attorney's number.
Okay, your attorney didn't show up. She was on there for a little while, but evidently she was riding and she lost signal, which is not hard to do around here, so lose signal. So I will,
So we don't have.
Carson, if she hadn't been sentenced yet, can y'all put some kind of pin on her or something, get her off the
Okay, not
dime?
till she's sentenced.
I don't think it'll matter because the penal will be retroactive.
No, it starts at six.
Oh, they don't do the pen, even though the alternative sentence.
Yeah. Starts at six. She'll still get credit for it, but the county still pays until alternative sentence.
what does that mean?
That means that we're gonna try to get you a sentencing date because your attorney's not here. We can't sentence you yet. Okay, and the county is stuck with your dime, but I'm going to direct that you be sentenced on.
Like, is my sentence still the same if I agree to do it today without my lawyer present?
Your sentence is gonna be the same. We just can't get you sentenced yet. July the 2nd, and I'm gonna order your attorney to pay the county back for the cost of incarceration between now and then on a contempt order.
Can I agree to do it without my attorney?
No, it won't cost you any time. Your time is still good. This does not,
Okay.
this does not affect you. If it affected you, I'd tell you, we do something about it, okay? Because it wouldn't be fair to you. We're gonna try to be fair to you, okay?
Thank you, sir.
We're just gonna get to pay each other costs for 2 weeks.
Yeah. Okay. Then we have somebody else over there, I guess.
Your Honor, did you say July the 2nd?
July the 2nd. We'll be.
Thank you, sir.
Yeah, we'll be.
Have a good day.
Judge, we got 2 more to sign, I have to fax that, Referrals and Guffy.
Guffey's gotta come in front of us, Pelis study.
Okay.
Yeah. You have the Guffey stuff back there?
No. Yes.
Yeah, I guess Mr. Guffey's the last one we have there.
Yeah.
Mr. Dunbar, you running a little low on help. You're having to do all this yourself here today. I don't know.
Yeah, we're running a little short,
I-
but his paperwork's been faxed back over right now.
Yeah, we'll get it. We'll go over and get it. I kind of felt like I made an appointment to see the chief of staff of Congressman Comer, and then Congressman Comer shows up. That's what I feel like keep coming in here.
That's all right, ain't it?
Yeah, we had a clerk, our main clerk wasn't here today. One of our bailiffs is on a motorcycle ride, which I'm glad because he's 76 years old, 77, so we're glad he's able to do that. One of our attorneys disappeared, ran out of cycle. And now we got you here, so this is an unusual day, you know, but you're the highlight, you're the highlight of it all. Time I might ask you to break out some of that Church of God singing you know how to do here in a minute.
Well, we can do it.
We'll get these paperwork off here as soon as we can.
Carson, I also faxed over that paperwork for Del Perales at the same time.
Thank you, sir.
Very well. Hello?
The original copy of that, will you give back to Dale? That's for him to keep.
Yes, I will.
Thank you, sir.
Great.
That's the facts, that was. Maybe I'll hold it.
However, is it James Guffy? Twenty-five CR 0032. Mr. Guffey's previously been identified by year of birth, 1971, and social security number 8258. It's 25 CR 0032. I understand there's a plea agreement here. Is that correct?
Yes, Your Honor.
What is it, Mr. Stockton?
It's a pretrial diversion, Your Honor.
Okay, sir, a motion's been tendered that says you wish to enter a plea today. Is that correct? Are you currently under the influence of drugs or alcohol?
No,
Is the plea given freely and voluntarily?
yes, sir.
Is judgment impaired today in any way?
No,
Have you discussed this matter with your attorney? Are you satisfied? Yes.
yes,
Have you reviewed the evidence the Commonwealth has against you? Believe you're fully informed about the case?
I haven't reviewed the evidence against me, no.
We've went over the evidence, Your Honor.
He says he's not fully informed.
I can review it while I can go see him if that's what he wants to do.
Well, I mean, I think, yeah, I'm informed it's a terrorist threatening second degree, because I walked in and said it's C4.
Okay, you understand? You understand that you understand that you do not have to enter a guilty plea today. You have certain rights under Kentucky and the United States Constitution. Before I can accept the plea, I need to know that you understand those rights. So I'm gonna go over them with you and then ask you at the end, okay? You have a right not to testify against yourself. No one can make you say anything. Right to speedy trial by jury, right to be represented by counsel at your jury trial, right to confront and cross-examine all witnesses called to testify against you, right to produce evidence, right to call witnesses in your favor, right to appeal this matter to a higher court if you lose, and right to require the Commonwealth to prove beyond a reasonable doubt that you're guilty charged against you. Understand it by entering a plea of guilty today. You give up all those rights. You understand that?
Yes, sir.
Reconsider the Commonwealth's recommendation, but I may apply any range of sentence provided below. I don't have to accept any recommendation. In the event I do not accept the Commonwealth's recommendation and decide to impose a harsher sentence, you have the right to withdraw your plea of guilty and proceed to trial. Do you understand that? Now I'm going to do some qualifying questions. Have you previously been pretrial diverted in the last 5 years?
Not that I know of.
Well, you would know about it, you know.
No.
Have there been any felonies in the past 10 years?
Not that I'm aware of. A lot of misdemeanors.
Okay. Are you currently on probation?
No,
You understand if you complete the pretrial diversion, your case will be dismissed pretrial diverted and you can have your record expunged. You understand that?
that's a good thing.
You know, do you understand if you not successfully complete the diversion program, if you're brought back in front of me, I could void your pretrial diversion, order pre-sentence investigation report to be done by probation and parole, sentence you, and you would have another felony. You understand that?
Another felony on top of it?
That could be used against you in the future if that happened to enhance your sentence. You understand that if that happens?
Yes, sir.
What is the Commonwealth's recommendation, Mr. Stockton, you come forward?
Your Honor, he would plead guilty to terroristic threat and second, receive a 5-year sentence, pretrial diverted for 5 years. He'd be supervised. He would have be a mental health assessment scheduled through probation parole. He'd comply with all recommendations of that. And he would pay court costs, discretion of the court, obtain employment if able, and all evidence in this case be destroyed.
Is that what you agreed to, sir?
Yes, sir.
Okay, are you pleading guilty because you did commit the acts charged in the indictment as amended?
Yes, sir.
You're doing so of your own free will, because knowing your constitutional rights is still your desire. Give up those rights, enter plea of guilty to the charges, and allow the court to fix your punishment. Is that correct? Hand me the document over here.
Yes, sir.
I'm gonna let you look at this and see if this is your thing. Is that your signature on there, sir?
Yes, sir.
I'll accept the pretrial diversion agreement. When was the release date on this, Mr. Stockton?
We had originally done a felony plea, and I didn't realize he qualified for diversion, and we was gonna release him at sentencing. So I don't mind releasing him as long as he sets up and goes and meets with probation and parole.
Okay, where are you gonna live when you get out?
I gotta find housing.
Okay, what I'm gonna do, what time can he see you tomorrow?
Our offices are closed tomorrow
How
and
about this afternoon? Can you see this afternoon? Somebody?
I can either call to the jail and see him or see him by Zoom at the jail.
Okay, I'm gonna let probation and parole contact you. I'm gonna let you out as soon as you finish, give them the information that they need. So if they can do that today,
I can use my father's address.
well, you need to talk to them directly. Probation and parole. They're gonna be calling the jail or coming by the jail today, and as soon as they're satisfied, we'll send a release order over there for you, okay?
Okay.
They're closed tomorrow for Juneteenth. That's the reason I'm gonna do it in the morning. So they're gonna try to accommodate you and get you out of that day, okay? Thank you very much.
Today?
What's the cost?
Thank you.
The court cost is $155. I'm gonna allow you to pay that $30 a month. First payment starting
Thank you.
30 days from today.
Yeah. Thank you.
Okay, is that
Thank you.
Russell County? Does that take care of everybody you got over there for us?
Yes, Your Honor, that's all.
Okay, thank you for your patience and your cooperation. We appreciate it. Have a blessed day. Let's go to Clinton County Jail. Clinton County Jail. Okay, Daniel Anderson. Daniel Anderson.
I'm sorry, can you say that again?
I'm sorry, 25 CR 55.
00055. Are you Daniel Anderson?
Yes, sir.
Your year of birth 1988.
Yes, sir.
Last four digits of your social security number 1882.
Yep.
You're here for the purpose of arraignment. You're by information. You agreed to bring it up by information. Your new case number is 25 CR 00065. 55. 00055. You have been charged with possession of controlled substance, first offense, methamphetamine, and also possession of drug paraphernalia. Is that right, Mr. Stockton?
Yes.
Are you currently, I understand you wish to enter a plea today, are you currently under the influence of drugs or alcohol?
No.
Is this plea freely and voluntarily given? Is this plea freely and voluntarily given?
I can't hear you.
Is this plea freely and voluntarily given?
Yes.
Okay. Is your judgment impaired today in any way?
No, sir.
Are you satisfied with the advice of your attorney?
Yes, sir.
You believe you're fully informed about your case?
Yes, sir.
You understand you do not have to enter a plea today. You have certain rights under Kentucky and the United States Constitution. Before I can plea, I need to know that you understand those rights. Now, I'm gonna go over the rights. At the end, I'm gonna ask you if you have any questions about them. You have a right not to testify against yourself. No one can make you say anything. You have the right to speed trial by a jury, the right to be represented by counsel at your jury trial, the right to confront and cross-examine all witnesses called to testify against you. Right to be miscellaneous, right to call witnesses in your favor, the right to appeal this matter to higher court if you lose, and the right to require the Commonwealth to prove beyond a reasonable doubt that you're guilty of charges against you. Understand that by entering a guilty plea, you don't give up all those rights. You understand that?
Yes, sir.
I may consider the Commonwealth's recommendation, but I may apply any range of sentence provided by law. I don't have to accept the recommendation. After reviewing a pre-sentence investigation report, if I decide to do a harsher sentence, or if I, or if there's no pre-investigation, if I decide to do a harsher sentence, then you can withdraw your plea of guilty and proceed to trial. Do you understand that? I'm gonna ask you some qualifying questions. Have you previously been pretrial diverted in the last 5 years?
No, sir.
You have any felonies in the last 10 years?
No, sir.
You're currently on probation.
No, sir.
You understand if you successfully complete this pretrial diversion, the case will be dismissed pretrial diverted and you can have your record expunged. Do you understand that?
Yes, sir.
You understand that if you don't successfully complete the program and are brought back in front of me and I find out that you're in violation to the point that I need to terminate your pretrial diversion, I'll have a pre-sentence investigation report done by probation and parole. You'll be sentenced to be a convicted felon and that would be used against you in the future. Do you understand that?
Yes, sir.
Mr. Stockton, will you come forward with the Commonwealth's recommendation?
Yes, sure. Your Honor, Mr. Anderson will plead guilty to possession of controlled substance first degree, receive a sentence of 2 years, pretrial diverted for 4 years. He would be evaluated by the SSC, follow all recommendations. He'd obtain and maintain gainful employment, all evidence be destroyed, and pay court costs at discretion of the court.
What's the court cost?
155.
$155 would be payable at $35 a month. Is that your signature on there, sir? You see that signature?
Yes.
Is that your
Yes, sir.
signature? Okay. I'll go ahead. I'll accept the agreement, sign the diversion order. There's no drug court or anything involved in this.
No, sir.
When can he see probation and parole?
I'll be down to the jail to see him as soon as we're done with court.
Okay,
So
as soon as they get finished here, probation, parole is gonna come down there and interview and I'll sign a release order for you, okay?
Great, thank you, sir.
Yeah, and you'll be paying it 35 a month. The first payment will be done 30 days from today, okay?
Okay, thank you, sir.
Okay. John Beatty.
You got there in the hallway. John Bates. John Bates. You get out?
Commonwealth versus John Beatty for arraignment, 25 CR 0053. Are you John Beatty? Are you John Beatty?
Yes, I am.
Were you born in 2000?
Yes,
Last 4 digits of your social security number, 8125.
yes.
You have a right to remain silent. Your attorney is here, your public advocate. The grand jury of Clinton County has returned indictment charging you with failure to signal, possession of controlled substance of first degree, methamphetamine. Okay, controlled substance in the first degree. You understand those charges? You understand those charges?
Yes,
Okay. Counselor, do you acknowledge the identity of your client received indictment, waive formal reading and arraignment, enter plea of not guilty, reserving all pretrial motions?
Yes, Your Honor.
I'm signing a reciprocal discovery order so that it requires the Commonwealth to provide you with all information to help you prepare your defense, scheduling a negotiation day on the 30th. And the next court day is on July 2nd. Okay, your attorney will be down to see. When are you gonna come see him?
I can see him today.
Okay, he'll be down to explain stuff to you today, Mr. Bay. If you have any questions, okay?
all right.
Okay, Cody Brown. Are you Cody Brown?
Yes, sir.
Good morning. This is 24 CR 0070. Mr. Brown, were you born in 1994?
Yeah,
Last 4 digits, social security number 1023.
yeah,
You're here on a probation revocation. It looked like Lance Turner previously represented you.
yeah.
Yeah, I don't think he's currently representing all through the firms. Lawyer and all.
Who's gonna be your attorney in this thing, Mr. Brown?
I heard Corey.
Okay, the public advocate. Okay, I'll go ahead and appoint it subject to review. Have him do it. What have we got here?
Let me go over this, he may not do much. Yeah. He had 3 positive tests for meth. He got a 3-year sentence on possession. He was terminated from SAP. He was sent to long-term treatment with probation parole. He left after 5 days, but he did turn himself in to Mr. Payne. So we had him assessed for drug court. He is eligible. So I'm willing to put him in drug court if he wants to go.
Mr. Brown, you gonna take a shot at being free here?
Yes, sir.
Okay, well, I'll sign a referral for drug court here, and they'll come over and interview you, and we'll try to get you admitted, and it's gonna take a few days to work it out, but these days are good days that you have. Okay, we'll try to get you into that. This is your shot, man. How old are you?
30.
Well, you still got plenty of time to have a good life out there, enjoy your freedom, so we'll hope that you get into the deal. The papers will be coming over, they'll come see you soon, okay?
Okay, thank you.
Okay, Tommy Claiborne. Tommy Claiborne. Commonwealth versus Tommy, are you Tommy Claiborne?
Yes, sir.
Good morning. This is 24 CR 0057. You born in 1974?
Yes, sir.
4 digits, your social security number is 00040. You're on a probation revocation. What does the Commonwealth have to say?
Your Honor, he's got a 3-year sentence on possession of controlled substance. He had 3 violations for failure to attend outpatient treatment, 2 positives for meth. He would not report until Mr. Payne went to visit. He was supposed to report on May 23rd. He didn't, the warrant was issued, then he reported to the officer on May 27th and was lodged. Mr. Claiborne's got a long criminal history. He's not eligible for drug court, though he's been in it recently. He's a nice, pleasant fella, but I'm surprised he's still alive, to be honest with you, as long as he's had a drug problem. So I don't know if the court wants to try long-term treatment in the Republic.
Mr. Claiborne was definitely open to long-term
Well,
rehabilitation.
I'm sure he is. Yeah. You know, Mr. Claiborne, what would make me think that you would be compliant in a long-term treatment? You haven't been doing too well as far as cooperating up to this point. What, has anything changed? Or did you just go ahead and serve your time out?
No, sir. You know, when I was out on the street, you know, I had doctor's appointments and, you know, the probation, I was having to go twice a month. Everything was compounded on me. You know, my problems were stacking up. I had been sober for a while, you know, going to IOP and everything. And everything, you know.
I don't want to talk about the past.
Yes, sir.
We know that you dropped the ball in the past. I want to talk about what you're going to do in the future.
Well, I would like to, Your Honor, I'd like to go to a long-term rehab to where I could help, not just get off of drugs, you know what I mean? I've been struggling with that, but it's to help get the rest of my life together, you know.
I know you don't want to, listen, I haven't never met anybody that really wanted to be a drug addict.
Yes, sir.
So I'm going to give you a shot here, just because everybody else has been so messed up today and you're willing to accept your responsibility, but this is it. Okay?
Yes, sir.
We'll find the public advocate's office will find something and they'll agree with the Commonwealth. Once they agree, I'll sign an order. I don't want you get there and they're mean to you, or you don't like the food, or it's not gonna get it. You're gonna stay there and work through it, okay?
Yes, sir. At this point in my life, I mean, I gotta do what I have to do, you know, if I want to stay alive and stay straight.
You wanna stay alive and stay free.
Yes,
Okay?
sir.
The order will be coming up there. Good luck to you.
All right,
Brian
thank you.
Gross for sentencing in a pretrial conference.
He has other charges with him.
There was a trial,
What's the charge?
the trial that you don't really have a trial.
He's got a possession, and he's got that, old handgun case, the really liking his imposition of it. I'd say if you want to go ahead and sentence him, so he'll be off the county dime, then we can have a negotiation on the other two cases.
Okay, Commonwealth versus Brian Gross, 24 CR 0031 and 24 CR 0041.
I think Joe's patience has been tested.
Well, I won't compare myself to Job until I start getting growths and warts and scales and stuff. I can take this.
Yeah, pretty true things. Saying as we deal with. It's justified, whereas some of it are.
Mr. Clark, is he going to be paying for her salary or credit for 35 extension? When I was praying, Mr. Cody, I gave him 31.
That's the situation. Over that, for money, but days to come close.
Yes.
Hey, you watch Wolf come back in? Yeah, let's see some guy. You go watch that all. You know how I ask him since college. I don't know why I just feel the way I do about Pollson. I don't give a damn. I don't like him. One thing I some great baseball players. You know, the shortstop, outfield play. Some pitchers. I know you can more up to date on smarter stuff, but it's a long term first. How they can. Muscle up in certain ways, it's crazy. What do you?
More than likely, you want to eat further. What are you talking about?
She knows no facts. She might be very full of my experience. That's just. We go back.
Yeah.
Finished.
Oh, get started.
Is that right? I really think we got much for y'all.
Y'all know?
Y'all on the record over there. Yeah, y'all.
It's on.
Been in there. Those two can go back up. Oh, yeah, I'm about to stick out. You didn't hit that, did you? No. What is it?
But when you didn't pay.
Okay, we got Brian, hopefully.
Well, you know, once they're gone.
Well, that was that. Get the jail back on.
It's divisive.
We get the jail back on.
How's that thing out? We have the right up. You just talked to Mosey? Alright, we need you. Oh, okay. Hey, you got another one.
Okay, here we are. We're on Brian Gross now. Y'all wanna come back up and get started on Brian Gross?
Sir, if I could, I need to re-go over my PSI. I was a little confused as to some of the stuff that was on there. And I want to make sure it's got updated information.
Yeah, oh.
Brian, well, if he wants to do that, that's.
Yeah, well, we'll go on with everybody else and then you can go down there and see Brian. I'll
So
still.
why don't we just go ahead and send this in and then they can submit an order, whatever needs to be changed.
Well, I can't sentence him if he says he's not familiar with what he's on the PSI.
I'm scared.
Well, that's okay, but he ain't going nowhere and so. Yeah, it's just 2 weeks. I'm gonna, do you have a copy of the PSI down there? You have a,
He doesn't have a copy of the PSI.
okay, well, we'll go on and skip him and we'll go to Matthew May.
I don't have a copy of nothing. I still haven't even sent mine.
He'll be down there to see you, Brian, in a few minutes.
Okay, and I still, even though I'm being sentenced on this, I still have yet to see my discovery pack or anything. Like I have no paperwork.
He'll be down there to see you in a few minutes.
And
Matthew May.
Matthew May.
And here's his ALI, Mr. Norman, and he said previously, but it's not been verification.
Commonwealth versus Matthew May, 25 CR 0048. Are you Matthew May?
Yes, sir.
Born in 1987.
Yes, sir.
Passport digits of social security number 0653.
Yes, sir.
You're here for a purpose of arraignment on one charge here. I'm appointing a public advocate to represent you. And I'm gonna wait till it's over to determine whether I'll charge anything for that, okay?
All right.
Until that for later. The grand jury of Clinton County has charged you with fleeing or evading police in the first degree on foot. Possession of a firearm by a convicted felon. Possession of controlled substance, methamphetamine. Possession of drug paraphernalia. And being a persistent felony offender on the fleeing and evading. You understand what those charges are? Counselor, do you acknowledge the identity of your client, receive the indictment, waive formal reading and arraignment, enter plea of not guilty, reserving all pretrial motions?
Yes, Your Honor.
We also have a probation revocation up in 21 CR 00014. So I would suggest that I set this for a negotiation day on the 30th and next court day on the 2nd.
Yes.
Is that correct, Mr.
Yes,
Stockton?
Your Honor.
And y'all can look at all those together, maybe your previous, we won't go ahead and revoke you today. We just let you negotiate that with the new charges, sir. And your attorney will be down there to see you.
And Your Honor, can we discuss his bond?
There's no. If you reach an agreement on a convicted felon with
I believe it's been on probation.
a probation violation. Yeah, okay. Thank you.
Thank you.
Matthew May.
Yes, sir.
Matthew May. Okay, Matthew May, can you hear me?
Yes, sir.
Attorney's gonna be down there and talk to you. Yes, about both these cases, okay? Joshua Minton. Joshua Minton. Joshua Minton, are you Joshua Minton?
Yes, sir.
This is 22 CR 0008. We're on a pretrial diversion revocation. Born in 1987. Last four digits, social security number 8105. What does the
Yes, sir.
Commonwealth have in this? Mr. Stockton will come around.
Yes, Your Honor, he has a 3-year sentence and, for possession of a controlled substance. He was placed on supervision and he had an active warrant for 909 days where he absconded. So we're asking for revocation.
Stipulate, Your Honor.
Stipulate. They've stipulated a violation, so I'll do a revocation of pretrial diversion order, pre-sentence investigation report done by probation and parole. We'll schedule you for sentencing on July the 2nd. And any motion for probation will be considered then, okay? Thank you. Dylan Murphy. Dylan Murphy. Commonwealth versus Dylan Murphy. 23 CR 0057. Are you Dylan Murphy?
Yes, sir.
Born 1996.
Yes.
4-digit social security number 1330.
Yes, sir.
Probation revocation. What's the Commonwealth have to say about that?
Your Honor, he has a 5-year sentence on wanton endangerment, criminal abuse. He was placed in the specialty court and he absconded on January 3rd, 2025. He also had some positive tests during that time. So we're asking you to be revoked.
Stipulate to that.
We'll stipulate to that.
Stipulate to that. We will go ahead and revoke probation. It's 5 years. Is that right?
That's correct.
Okay. Thank you very much, Dylan. Caleb Purdue.
Did you set sentencing on Dylan Murphy? Is he not pretrial diversion?
I got probation.
Oh, he was probation. Okay, I'm sorry.
Caleb Purdue. Are you Caleb Purdue? Are you Caleb Purdue?
Yes, sir.
This is 21 CR 0022. Mr. Purdue, you born in 1994.
Yes, sir.
Last four digits, social security number 5966.
Yes, sir.
We're on a probation revocation. What do you have on Caleb Purdue?
Your Honor, Mr. Purdue completed drug court, I believe it spring or fall of last year. I can't remember when. After he completed drug court, he tested positive and was placed on supervision. He had enough positives. He was sent to inpatient treatment. He completed that. And since he's got that inpatient treatment, he's had 2 more positives. So there's nothing else that probation, parole, or drug court can do for him. He just will not quit using them. So we're asking for revocation. He has children by Miss Taylor Phillips, who was up earlier, that's pregnant, that we sent to long-term treatment. And the only reason I didn't ask for her to be revoked was because she was pregnant. But Mr. Purdue's about the same boat.
I would like to see him give him opportunity for long-term treatment.
He's already been given all these opportunities. You know.
Yeah, dude.
Your Honor,
Yeah,
may I speak?
yeah, go ahead.
Your Honor, I would be willing to do a 12 to 24 month treatment. I know I've already been, and and I really apologize for me having to come back in front of you. And this is from my heart. I'm getting ready to have another little child, man, and I really want to be on the street to take care of them. I messed up, yes, I did, but I really, if you would give me one more opportunity to show
How
you
many
guys,
children do you have?
huh?
How many children do you have?
I have 4 currently, Your Honor, and I'm getting ready to have another one. And I know it's been a minute since I'd messed up, and I really, really wish that you would give me another opportunity to do at least 12 to 24 months rehab. And at least stay where I'm going to just get out of Albany. You know what I mean? That way I could, actually stay sober.
Albany's not your problem, man. There are a lot of people that come off drugs that stay in Albany. You're your problem. And you've been given all these chances, and it just today, we sent your are you married to this woman, or are you?
Yes. Yes, sir. We are married. Yes,
wife
sir.
up so that the baby she's got won't have drugs when it's born. And I can't tell you the way rehabs are, whether I can guarantee she won't be exposed to drugs if she wants to be at the rehab. I don't know what to do with you, man. I don't know what to do with.
Your Honor,
how much time does he have?
He's got 10 years since, but personally, you'd have to pull his file. He's probably got quite a bit of time in before he's been sanctioned.
I'd
So-
have to figure it out.
Well, I'm gonna leave the hold on you here, and we're gonna take a look at it, and we'll come back on July 2nd to take a look at what you're doing. And you need to do some prayerful consideration between now and then, and you see what's available. I mean, I don't really see the difference. If he's gonna do 24 months rehab or something, let him go ahead and knock his time out.
Yeah, I understand
So
that.
we're gonna look and see how many days you are and whether it would be your advantage just to knock your time out and go to rehab. And then we'll have it back there on
I'm about
July.
to the point rather than if you do decide to do a sanction, I've been in the case, so we have time in jail. Let's go back to rehab.
Well,
I mean,
that's what we're gonna look at. I'm gonna just look at, see, serve it out. And the probability of him successfully completing rehab is not very great. So we'll take a look at it, since I don't know how many days he's got in. I mean, I could sanction him and I could do this, but I think you'd be better off serving out in a penitentiary than doing jail time down here at the Clinton County Jail on a sanction.
Yeah, I agree.
You know what I mean? So we'll take a look at it on July 2nd.
Your Honor, on Dylan Murphy, we need to set a sentence on him. I think that was a pretrial verdict.
Says probation revocation on the docket.
It was pretrial version.
Okay, well, we'll order a sentencing on July the 2nd on Dylan Murphy.
No.
Harold Toole. Harold Toole.
He's coming, Your Honor.
Are you Harold Toole?
Yes,
This is 21 CR 00135. Were you born in 1983?
yes,
Passport digit social security number 8178.
yes.
You're on a pretrial diversion revocation. What does the Commonwealth have to say? 21 CR 00135.
Your Honor, I think he has a 5-year sentence on trafficking controlled substance. He also was in specialty court. He completed that on November the 18th. Then on January the 3rd of 25, he was positive for Suboxone. On 3/29/25.
5 days later?
What?
Is that 5 days later?
No, he graduated drug court November 18th, 2024. But in January 30, he was positive for Suboxone. March 29th, 25, he was positive for Suboxone. He didn't have the prescription at that time. Then on May 29th, he's been going to a Suboxone clinic. He's positive for Suboxone, but he's also positive for meth.
Which is, I didn't really do it on purpose though. I hit somebody's vape that had it in it.
Harold, I'll say this for him, when he was in drug court, he did well and worked at Tyson's. I guess you still got your job at Tyson.
Yes, sir. I still have my job, 2 jobs, as a matter of fact.
I hate to send him to penitentiary, but he can't continue to go to Suboxone clinic and use meth. That's the problem, Scott.
I won't use no more. I promise I won't. I got 6 children that depend on me. That to keep my job.
What about, do you think you can make it without Suboxone?
You mean stop Suboxone?
Yeah.
I'll quit if that's what it takes. Yes, sir.
Well, I mean, it's easier to come off these other drugs, they say, than it is Suboxone. It might be the hardest thing to come off of, but you take
That's what I've
them both.
heard.
I
Don't
will
need
do
to
it.
be
That's
taking
what
a
it takes
hit off of me. I mean,
to provide for my children.
wait, you taking a hit off somebody else's pipe or something like that when you're taking Suboxone? What if it
Yeah,
has,
they're putting it in
be quiet. You
I'm
be
sorry.
quiet.
Yes, sir.
You're already talking too much. You got 1 foot in the penitentiary. I'm telling you, that could have fentanyl in it and your 5 children be left out there orphaned. So I don't want to hear about this, why you were using this or that. I've heard all that. I want to hear. Okay.
Payne says he can give him a bad day, but if he's on Suboxone, he helped him off bed. It's not going to do any good.
Well, he's not going to be able to work out here either.
That's right, so.
Maybe sanctioned time, would that be something? Or be open to
do what?
To just give him like sanctioned time for this so he can get back out and work, since he has a job at Tyson.
Do they do work release out of this jail down here?
I would prefer just doing home incarceration with ankle monitor rather than having to go in and out of the jail.
I'm going to give you a 90-day sanction. 90 days on home incarceration. So if you keep your job. So they'll be down there to sign you up. okay?
And
And Harold, I don't wanna be mean to you. I don't wanna be mean to anybody. But the dog ate my homework. Is the reason I don't have my homework does not work anymore.
I understand, Your Honor.
You go out there and you work and we'll put an ankle bracelet on you and be supervised.
Yeah.
And you waive your Fourth Amendment rights, the probation pro people can come and look anywhere in your house they want to. You understand what I'm saying?
Yes, sir. Your Honor, I'd also ask that he be assessed with SSC and maybe they can come to some kind of agreement whether he needs to stay on this boxing or come off of it or something.
Well, that'd
Maybe
be
get some
better to
help.
do that than me taking him off of it.
That's exactly right. I think he needs some professional help.
Okay, so they'll tell you how you get evaluated by the SSC people, okay?
Okay.
I hope you get to see your children. I hope you get to support them. But it ain't, you're headed in the wrong direction now for that, okay? Now, we've got, they'll be down to see you. And,
Okay.
yeah, thanks, all good. What about, we back up to Brian Gross. So we finished everything else here? So we're gonna take a recess here. You go down there with the paper and see Brian Gross.
I will.
And then y'all can appear by Zoom from down there. Okay? Thank you very much.
Thank you.
We go off the record here.
Yes.
We're gonna go off the record here and wait for Brian Gross to review for sentencing. So let's go off the record.
Attorney's come down to see you. I want to talk to the judge, not my attorney. My attorney's is shitty. Well, the judge don't want to talk to you. I need to talk to the judge, man. That's not the way it works. The attorney's coming down in front of me, and I didn't get to say what I wanted to say, and they brought me down here, man. Will it just pop up when it's gone or what?
It might be up on it. Oh, yeah, they're just about to go though, I think. They said they're watching for us. My bet is that they're getting the judge back in or something.
Commonwealth versus Brian Gross, 24 CR 0031 for sentencing. And 24 CR 0041. Mr. Gross has previously been identified on the record that said they hadn't had an opportunity to look his pre-sentence investigation report. So we sent it down to the jail counselor. Have you been able to go over it with Mr. Gross?
Yes, Your Honor.
Is it
Your Honor,
substantially correct?
if I may, I'd like to address the court.
I'm going to give you opportunity to.
Okay, thank you, sir.
I'm just be a little patient, okay?
Your Honor, it is essentially correct. There are a few items that we added involving his medication, but I'll make sure that probation and parole is aware of that.
Okay. Okay, now, Mr. Gross, you'd like to say something?
Yes, sir. I understand that we've already had the trial and I was presumed guilty, but I just wanted it to be on the record that if they review the body cam footage, it approved that what I said when I took an oath was the truth and what he said was a lie, sir. And that was what I've been trying to say this whole time. When he knocked on my door, he did not inform me that he had a warrant. I told him it was not my house. He could not come in. He still never told me he had a warrant on anybody. He asked me if Miss Abby was available, if she was home. I informed him that I just had woke up and that I didn't know if she was there or not, but I would check. But I told him he did not have permission to come into that home because I was not the owner of the home. Now,
Okay.
after this,
That is, that's over with. That portion of it is over with. So you've had an opportunity to have your say. You don't agree with what the jury found.
but now on this PSI, I was trying to go through it and make sure everything was right, and he's rushing me through it. I still didn't have time to go. He said they can make corrections to it or whatever, but I still, just to be on the record, I need more time to go over this PSI so I know that everything on there is correct. And that was the only thing that I was asking for. I apologize.
It's my belief that you had enough time to go with the pre-sentence investigation board. So the jury recommended totals sentence of 3 years, so I'll sentence you to 3 years. Now, what about the other charge that he has?
Well, do we need a trial date? We can get a trial date on the other possession, or if he wants to have a negotiation, we can do that.
Okay, let's set negotiation up on July the 30th. The next court date on the other charge is on the 2nd, okay? Okay, thank you very much.
Thank you, sir.
Thank you.
Includes Clinton Circuit Court. Oh.
Is there anything else that you can add to this?
Child support docket, it's called child support docket. Dickerson versus Ash. Dickerson versus Ash.
It's Stephanie's case and it's, Michael Ash.
He should be getting out today. He needed to preach all the versions today to be released today, so.
Okay, this.
This is the younger, right? I think there's like a senior and a junior.
You would not know.
Not know.
Maybe we should
Yeah.
pass it.
We'll
Okay.
continue this because it is for a default judgment, so we'll make sure that we get the right one. Don't want to do the wrong one.
Cabinet versus Cody.
Judge, this is, I think Stephanie submitted an order, and child support to $199 a month effective March the 1st.
Okay. Mary Doge versus Crystal Cornwell.
Yes, this is an arrearage case from Florida and asking that the non-custodial parent pay $600 by July the 1st, and we've submitted that order, Judge.
Okay, electronic file cabinet versus Hughes.
Judge, we have an agreed order. We have submitted that, Judge.
Okay, be electronically entered. Cabinet versus Reamer.
Judge, we're going to pass this for another date.
Cabinet versus Starnes.
And Judge, on this one, going to get another date, pass waiting on get wages so we can get an assignment on that.
Any
case.
other matter?
That's it, Judge.
Okay, thank you.
Appreciate you.
Okay, we have a Monroe County civil case.
Your Honor, Little Clark on behalf of Mr. Donahue.
Yeah.
We have I just recently entered an appearance on behalf of Mr. Pearson. He is left for another firm, so first foray into this case. We have a motion to set this matter for a final hearing. In your April order, he's asked us to come back and get a final hearing date in this matter once the DCBS investigation was finished. That's been complete. And then we also have a few minor issues when it comes to discovery. We filed a motion to compel discovery in this matter. Mr. Pearson served discovery back in April. We still have not received any of the documentation, nor have they responded to the request for
Who's
admissions.
the attorney on the other side?
Mr. Hendricks.
I am, and I'm appearing by Zoom.
That was some other books. It's just this. I know, but I want to look at that discovery. You attached as an addendum. That's a
Yes, sir.
discovery motion.
Yes, sir.
There's multiple pages. That last night.
I have another copy of the court record.
I'm fine with you, what you say. There it is. Is this, are these requests, these interrogatories? These interrogatories and requests for admissions, are they the normal way you practice things? Been a while since I've done very much domestic, but I've never seen anything that lengthy, almost burdensome.
Yes, sir. This is typical how we practice throughout the rest of the Commonwealth.
And Judge, and briefly
You
respond.
need to speak up, you need to speak up, okay?
Yes, sir, I will do so. And Judge, a little bit of what the court is voicing was some of our concerns. We weren't ignoring these, and I responded to prior counsel about them, let them know we are working on them. But part of the concern is this was their motion, and then they seem to basically be asking us, what's our cause of action? Well, we've been waiting for the cabinet investigation to be completed. That would be a big part of our answers, and it has been now. But a lot of this is basically just going to be, this is your motion. What are you bringing forward? But we are trying to, within the confines of preparing an answer for their motion, trying to answer these and get those back to them.
Okay, wait. Come with me again here on I mean, when are you gonna, if these interrogatories are things that you're used to handling, when are you gonna have these interrogatories and requests for admissions answered?
Judge,
Wait, and do you need clarification on some of them?
Probably on some of them, but real quick, I will be out.
I'm having trouble understanding you. Look, if you turn your head either way,
Try this.
I'm losing you. You're gonna have to directly speak into the microphone, because when you turn your head, I'm losing you. Yeah. Okay, let's hear you now.
Can you hear me better now?
Go ahead.
All right. Judge, I was going to say, as far as answers, I'm going to be out for 2 weeks, but I can get the answers back by then. If counsel will clarify any issues, I think hopefully I can work it out with him. The new counsel and I have not had a chance to discuss this, but it would be my hope that we could work it out and get them some satisfactory answers. Really, I need about 3 weeks because I'll be out for 2.
Your Honor, I think that in lies part of the issues in this case. If we wait 3 weeks, additional 3 weeks, now we push discovery into July, school's coming up in August, and there are some relevant issues that need to be decided between now and the new school.
Okay, like what?
Well, for instance, the youngest child, the 14-year-old daughter, is not with my client over the summer break per the court's order. On the day that my client was supposed to pick up his daughters, opposing party refused to turn them over for summer parenting issues or summer parenting time, and then a week later allowed the oldest daughter to go with him. The youngest daughter is still here in Monroe County. My client's not having his parenting time. And if what the oldest daughter would like, who's 16, is come to live with her father, that needs to be decided before the school year starts in August.
Okay, well, let's do a thumbnail sketch, Mr. Hughes. What do you think the problems are in this case? Wait a second. What relief are you asking overall? Let's go once upon a time.
Okay. Following hearing as to custody, control, and time sharing between the parties. It's clearly an issue of communication. From what we can tell, the oldest daughter wants to live with the father. The father would like to have some parenting time with his youngest daughter, who refuses to come to Indiana. So that's the issue number one. Issue number two is the failure of the opposing party to even communicate with my client. So recently, opposing party signed the youngest child up for therapy, did not tell my client. Apparently, the therapist has issued a report that Mr. Hendricks has seen. Myself and my client have not seen that report. It's clearly just opposing party does not believe that she needs to communicate anything as to the well-being, care, or custody and control of these children to my client.
Okay, and what would it take? Mr. Hughes, you're about the older child. What's your client's position on who the older child should live with?
Judge, she strongly believes that both children should live with her and that both children want to live with her. They have always, since the part.
I argue the case. I'm just saying that's the issue. So we're honing it down. It's who the older child should live with. That's the issue.
Yes, and parenting time with his second child.
Okay. The next issue is if the children are with the mother, how much parenting time should he have? If one of them is with him and the other one was with the mother, how much parenting time should the mother have if it went that way? So it would depend on how that broke. Now, are there any other issues to be decided other than that?
think that's the core of it, Judge, but I want to point out that this all started when Mr. Donahue called into CPS, made a report, then filed as if it was all true. And CPS has now conducted its investigation and unsubstantiated any of the claims. So really, I'm not sure at this point that they have asserted uh, what the change in circumstances are that would justify um, any change in the custody or the visitation arrangement. And I think failure on their part to do so is enough for the court to say that we don't need to have a trial until they can allege what has changed to justify the court reviewing the situation. There's no need to move forward.
Well, we often see things that are unsubstantiated that end up having happened or been true. The fact that they're unsubstantiated has some weight in the fact that this independent body didn't find that. So, I would suggest, that, you can measure twice and cut once. We won't wait until August to do this. I'm gonna go ahead and give you 3 weeks to conclude this, answering interrogatories, request for production documents, and everything. I expect it to be completely complied with during that time period. Now, once you get those, you can determine whether you need some time after that to do some research. If not, get a hold of me and we can schedule it in short order.
Yes, sir.
Okay? And then we'll schedule a hearing in short order if I find that you obviously made allegations sufficient to get to a hearing. Okay, I think that's a fair resolution. And Mr. Hendricks, I accept your word on this thing. You'll have this completely complied with. And of course,
yes, sir.
One of the reasons I would like to have a family court, because if I had to, fill out these interrogatories and request for production of documents, I'd rather pick up cans than do the detailed stuff that you have to do. I don't see that. It's not done in the practice here very much that I see, but you're entitled to do it. So, okay, if you'll draw an order up and send it to Mr. Hendricks, okay?
Will do, sir.
Thank y'all very much.
Thank you. I don't know
Thank you,
if
Judge.
maybe excuse.
Sure.
And that's all for me, Judge. Thank you.
Have a great day. It's 1:16. The docket doesn't start until 1:30. If there's anybody that has both sides of anything here that wants to jump to the head of the class, so you're not, we'll go off the record. Wait a second, we're still fine. It's, if I get to the case and the parties aren't here, we'll just go to the next case. First case on the docket is Chelsea Albertson versus Jameson Cooper.
Good afternoon, Judge. How are you?
Said good morning, good afternoon.
Yeah.
Judge, I'm appearing on behalf of Mr. Cooper.
I represent Chelsea Albertson in this case.
Okay.
And we filed a motion. It's regarding,
You need to speak up a little bit.
this is regarding some sensitive matters regarding a minor child, and we had moved to suspend the visitation at this time.
Yeah, I read the motion and has the cabinet been involved? You said the cabinet is.
No, actually, I've been in touch with the advocacy center, and they need a court order before they'll release the results of their findings. So,
It is the advocacy center, is not the cabinet, is it?
no, but the state police have been involved.
Well, I asked you if the cabinet.
The cabinet was
Is
called,
that
and
yes or no? I don't.
they are
understand.
not due to the age of the perpetrator.
The alleged person.
Yes.
So there has been a police report made.
The advocacy center's done an interview, and we've not been able to get those.
I'm not getting responses to my question. I have specific reasons why I ask my questions. You know, why I'm asking. So there hasn't been a police.
The state police have been involved.
Now, the allegations do not have to do directly with the respondent here, but have to do with the respondent's relative that lives proximate, correct?
Yes, that's correct.
Okay, well, I would say that what you should seek now is an order not allowing those children to go into that house until this is further investigated, and for none of those people in that house to be able to come to his house while the children are present.
Okay, the child has anxiety when he has to go there.
He's not gonna have to go there. He's not gonna go there, okay? And I understand it's a serious matter. I'm not putting it aside, but the only thing I can do right now is enter an order to keep the child from going into that environment or having anybody from that environment that your client might have doubts of from being around the children, period, even when they're at his house. And that should take care of that until we find out more. And then if you once you investigate more, or the state police or whomever investigating this, give a report, then we can have a hearing predicated on that. But I would dare say that you won't be able to find very much about what happened over there at that other location if you inquire about it, because people aren't want to make admissions about things like that. You know what I'm saying? So we'll just have to let it play through. Would that be amenable to your client?
Your Honor, that's exactly what we offered when we received this motion.
Yeah.
It's a prohibition of contact between the two residences.
Or anyone that is the resident. Some of them
who's-
might have to be unnamed
Yes,
if they're,
that all visitation take place at my client's residence, not at his grandmother's. There's no contact, there's no intervisiting. That's what we offered. And as a result,
what's the weakness of that?
The anxiety the child exhibits
Well, you can't do
when he
anything.
has to go with his father.
Well, that's a different issue. The anxiety he has with his father shouldn't have anything to do with something that happened someplace else if there's not an allegation that the father participated in it. You haven't made that allegation.
Not at this point. no.
Well, I mean, that's the point we're at this point. That's where we're at. So if you'll draw an order and send it over to that.
I will, could I address one other issue real quick?
Absolutely. You don't have to do it quickly. I've got plenty.
When this motion was made, that was the offer that my client made. I had communication with Ms. White about that. We even tried to have visits on Father's Day, was denied except at Mom's house. My client, as a result of this motion and the refusal for visitation, has missed 3 weekends, 1 week in June, that he normally has the first week in June and Father's Day. And we would ask the court to rectify that problem and order how that missed time can be made up.
Yeah, y'all need to go back there and talk about that. Cause I'm gonna tell you what, you cannot self-help in these things. You cannot go against court orders. You know, if you have and I understand that I have no reason to believe you're not in good faith. I'm not saying you aren't in good faith, okay? But even if you are in good faith, if you get placed to these situations, you should immediately seek counsel to try to get a modification temporarily to the order. You cannot just take it upon yourself. So if y'all go back in the room, see if you can work something out on some makeup time, okay?
Thank you, Your
One
Honor.
other thing, Your Honor, on the order that we need for the Advocacy Center, I will tender that to you through e-filing. Require-
Everything's supposed to be tendered through e-file.
Well, they require that, so they won't.
Well, the rules of justice require you filing everything now, so we'll understand that, okay. Tim Moons versus Ashley. You have no objection to opening it and filing this, correct?
I do not, Judge. The only issue I took was the wording where he's alleging what the allegations were for his agreement with the Kentucky Department of Education.
I really don't even think that it was necessary to go into that sort of thing, you know, I guess that's public record there where there was, he has to violate anything, but you know.
Judge, I just provided a copy to the clerk. It doesn't say what Mr. Gibson has indicated it
What do you
says.
say it says?
It's basically, he says that he denied the allegations, but he's agreed to voluntarily surrender a certificate.
We attached a copy of that for our motion if we didn't.
It was
I
not.
certainly agree.
Wasn't attached, and that's not what you said exactly, so I tell you what I'd like to do. Is that I'd like to strike those pleadings if they are contrary to what the facts are, just so that it won't exist.
So if we have a complete copy of the file, which is about 529 pages and.
I'm just wanting to say what the order said. I don't want to go up there and we're already killing ourselves going through all the testimony that's happened in this case. And I'm not going to go through it 500 cases. The point that you make is you want to open it up to get that order put back in.
Yes.
I'm not going to include all the testimony in that case, in this case. But I do think that you have a right to get that order in. So if y'all will, I don't know how we strike a plea on electronic filing, but we'll figure out how to strike a plea, and you just give a modified motion and attach the order itself. It'll speak for itself, okay? And we're diligently working through this thing to try to get an order, okay?
Yes, sir.
Okay, well, thank y'all very much.
And one other thing, did you ask for that
I
check?
haven't had a chance yet.
My client paid off the vehicle, and the company that it was financed through submitted a check. Because that was part of the property they had agreed he was gonna receive, and the check came in both their names. So I was just asking if she would sign
You have the
that
check,
for an overpayment.
Yes.
I've got the check.
$300-something refund.
sign the check,
No problem.
okay?
There. Yeah.
Thank you. Thank y'all. Kentucky Farm Bureau versus Barry Russell. Hello.
Good afternoon, Your Honor. AC Donnie on behalf of Planet Kentucky Farm Bureau. This is Farm Bureau's motion for summary judgment.
I read it last night. Who represents Mr. Russell in the city?
Previously, he was represented by David Smith, but he had formally withdrawn.
Was it like 13,000 or something like that, wasn't it, or something like that? What was it?
Check, Your Honor.
I read it last night, but I don't.
13,310.50. The motion for summary judgment was supported by an affidavit.
Yeah, I saw it. Yeah, I read it. You're good. We'll go ahead and enter that, okay? Okay, thank you so very much.
Thanks, Judge. Good seeing you again,
Yeah,
sir.
bless that. Okay, LVNV Funding LLC versus Tracy Cross. Okay, you have a motion for summary judgment. And I didn't know that exactly who was related to. I want to tell you that my staff lawyer, myself, and some of the other lawyers that were here had a conversation about an e-filing outside of your presence. If I'd known that you were going to be here, I would include you in this discussion, because none of the facts of the case had to do with your particular case. But once we started looking at it, one of the things I was looking at it is how you show distribution on motion for summary judgment. Mr. Cross brought up in his response that he had not received a notice for the motion of summary judgment, although he had filed an answer.
This morning, I just filed it this morning.
No.
So
Well, it was like two paragraphs.
I didn't get any notice. I found it on Friday when I put it on the job.
So
They
the,
just handed me this case yesterday, so
you what?
I only got this case yesterday.
Well, you're both about the same situation.
It
You got
looks
it
like it
yesterday.
was
Mr.
mailed
Cross
to-
hadn't thought of it for 3 or 4 months.
I hadn't thought of it for about 2.5 years. That's correct.
This is
Y'all on
supposed
pretty
to-
equal grounds here.
I didn't get it. I didn't get it.
Okay, the issue is
Okay.
here, and I guess,
I found it Friday when I looked through the docket.
Okay.
the issue is here is on the motion, and we looked at it, there wasn't any distribution listed on it, and I would,
There wasn't any certificate. There was a distribution. I'm on the distribution.
on the filing, there wasn't any distribution listed.
Oh, there wasn't. Yeah, the clerk's office did not distribute it to me.
Well,
Yeah.
either they, what I was asking, how am I supposed to know? Well, so if you do electronic filing, I guess you don't do a certificate of distribution like you used to do. Did you do it? It's not on the file. Would you look at it? Have you looked at the motion?
It's my first time here, Your Honor. I'm sorry.
Welcome to Clinton.
Yeah, well, okay, so I'm gonna pass over this. I'm not gonna do a summary judgment because I'm not, as we go through this transitionary period of e-filing and things like that. If someone e-files something, it would appear to me that when it's e-filed, it's automatically distributed to everybody that's had a pleading there, unless you restrict it. But there's a place on there where you check who you want to distribute to when you e-file. Isn't that correct? You don't e-file? Well,
I'll let my office take care of it.
okay, but I'm not gonna do it
We're in
today.
the same boat. aren't we?
What y'all need to do is go back there and
You don't know anything about it.
you don't know anything about that.
I know some about it.
We'll
Like
step
I
back.
could accept that.
Okay, well, I'm gonna pass over this and I'll give y'all some time. Now, the next rule day is shorter than usual. It's on July the 2nd instead of the 10th, so just a couple of weeks here. So I don't really, what's the underlying aspect of this case?
It looks like it's a debt of about 34,000
Over
that we
what?
filed for in
Over
two
what
thousand
was
fourteen.
What it was over, Your Honor, was these folks assisted my client with obtaining some tax relief and some tax credits. And he was unable to take care of them when he needed to. So they filed suit and we filed an answer and we hadn't heard anything about it since, but
Yeah.
he's prepared to resolve,
Okay.
as you might expect.
Do you have any authority today?
I do have authority to accept a,
Well, don't tell me what it is.
Okay.
Okay, why don't you go back there and tell Mr. Cross what your authority is? Okay,
Okay.
thank you very much.
I've got some other stuff.
Appleby versus Johnson.
I've got some other stuff.
Well, it's not very much stuff be here. Appleby versus Johnson. Angie Capps is involved in that.
Sorry, John.
Appleby versus Johnson. Ms. Sawyer's involved in it. Mr. Cross is involved.
I think Ms. Sawyers was appointed as a guardian ad litem in the juvenile action, and I just gave her a courtesy notice of this. I don't think she's actually a party to this action.
Yeah, I saw it on the distribution list.
Yes.
What do you have here?
Judge, I was just asking to set a hearing date on our motions for custody.
Where's your client?
Your Honor, I filed this for Mr. Appleby through his, the requested grandfather who's in the courtroom. Since that happened, there was a tremendous explosion in this family involving some sexual abuse allegations and such. And an individual outside the family was in fact convicted. But I have been advised by Mr. Appleby, come on, Mike, that he, at this point in time, I've not been authorized to continue representation of Mr. Abbott, even though with violence. What you told me was several weeks ago, you just wanted to drop it all as far as what I was doing. Is that correct?
Is that, he said she can take it.
So
you want to dismiss, you would have no objection dismissing litigation.
No, Judge, I mean, we've still got the mother who is also a party. And she didn't appear, I mean, if we could get an order where my client has sole custody of this child.
Well, I mean, I don't know whether that's within my province to do that or.
That's why I was asking for a hearing, because she has been admitted by the parties as a third party intervening third party. And we filed a de facto custody motion for her to have sole custody.
she has the child now.
And she has the
And that's-
child,
and
and
that's
she's
who
had the
mine is
child for
fine.
well over a year.
That's who she was fine, what you're saying.
Yes.
I mean, I think he could agree that he's not contesting
Well-
the custody, but.
And the biological mother is the one that's in this suit because she was brought into it, correct? Did you, I guess you filed this.
He filed original custody action, and then we filed the intervene, Judge. But at the time that my client filed this action, she had had custody through a juvenile action for a considerable amount of time.
Where is the mother filing pleadings in this thing?
No, she has not. So she's in default.
Well, I would suggest that, before I dismiss the action, you file a motion for default. Did you were guardian ad litem in the thing?
I was the guardian ad litem in the juvenile case, yes, Your Honor.
See, I didn't have access in these pleadings to your report. So if you could send me a copy of the report before I act on a default judgment situation, I think that'd be the best way. And then once a default judgment against the mother is considered, then you can dismiss the case as far as he's concerned. That sound like a good way to approach it.
I guess, Judge, since he's a biological parent, I don't know that we can dismiss him as a party, but I think he could agree to not objecting to my client having custody. I think he is. He could.
We're prepared to enter into. Mine's kind of managed grandson. Grandson, grandson. He's kind of managed it for years. He says that we'll enter into an agreed order.
My
So I
grandson
can.
also, and he said he would.
Okay, well, I'll just, y'all work it out and get me in order and,
So this.
but I wanna have an opportunity to personally review the guardian ad litem report that you filed, okay?
Your Honor, in the juvenile proceedings, we
Yeah.
typically don't file, as guardian ad litem, we don't file a report.
Well,
As
I'm
we
gonna appoint
do.
you as guardian ad litem in this case too.
And then you would like for me to prepare a report.
Yeah, I think.
I'm happy
that's-
to do that.
Yeah, so
I'm happy to
you've
do
already investigated. I think there was some discussion at a previous date about the fact that somebody asked me about a guardian ad litem. And we knew that you've been involved. So if you'll,
Okay.
if you need.
I'm happy to prepare
If you
a
need to update it in any way, you can do that. too,
Okay.
also. Okay, thank you very much.
Thank you, Your Honor.
You know, out of an abundance of caution, you know what I'm saying. Okay. Okay, Gormley versus Pierce. Okay, so we'll pass over that one then. Steve Byer versus Gary Wallace and others. Hello.
Brendan Shevlin on behalf of the plaintiffs.
Your Honor, we're here on a motion to dismiss that I filed on behalf of Ms. Donna Wallace,
Right.
who is somewhere here back in the courtroom.
Yeah.
Mr. Shelvin and I have had an opportunity to discuss this case prior to the case being called. And I think we've got an agreement on the issues that were raised in my motion to dismiss and in his response.
Yeah, well, I read both of them, and as a matter of fact, before you got here, I had a general discussion of law with Mr. Cross and some other people here that are oil and gas lawyers without looking at any of the facts of your case. I have no doubt that this property can be executed upon. I have no doubt about that. Now, whether anybody would want to buy an estate based upon the life of another, I wanted to almost call Leonard Jaffe, my old property professor, but I'm sure he's no longer alive. you know, but in any event, I thought we might do the rule in Shelley's case and the rule against perpetuities and just bring all that stuff back out. So it wouldn't be to anybody's advantage, I don't think, for someone to execute on that and have an estate based upon the life of someone else. I would think at some juncture there'd be a possible evaluation of some of those sort of things if you work out, but I hope y'all can work this out. And what do you got in this thing, Mr. Little?
I just represent a lien holder, Albany Ready Mix. And it's just a lien against Gary, not against,
Your Honor, Mr. Sheldon and I will submit an agreed order.
Okay, that'll be good. Mr. Cross, you're just
Almost
here.
innocent bystander because.
I doubt, I very seriously doubt that. So, thank y'all.
Thank you.
Okay,
Thank you, Your Honor.
yeah, it's okay.
This concludes my business. May
Yeah,
I
absolutely.
excuse-
Have a wonderful weekend.
Same. So if we've got an agreement, we'll be submitted.
Okay, okay. That'll be great. Laura Claiborne versus Leslie Catton. I don't know whether everybody was leaving, or everybody's in this case.
We're just moving around here. You do have a guardian ad litem report now. Your Honor.
Hey, what do you need here?
This was our motion for joint custody and visitation. And my client had agreed in the beginning to start out a gradual schedule. And that's pretty much what the GAL had stated.
Your Honor, that is what the guardian ad litem stated. Housekeeping measure, I realized in reviewing the pleadings that Ms. Claiborne ought to be dismissed as a party because Marcus is 18. I can make a formal motion on that if need be. He was not 18 when this started. So she's got no standing now because he's an adult. But we are prepared to attempt to enter into an agreement with Ms. White regarding some initial, very graduated visitation in recognition of what the court will likely follow from guardian ad litem report. And our position on that is let's ease into it, see how it goes, and come back and review it and see if we can extend it, or if not, we'll have the court rule on it. So we could try to work something out today while everybody's here.
Yeah, that'd be good. Get back there and see if you can work something out. It's not the sort of thing, it's gonna be very difficult, even with a gradual situation, to introduce people into the life that the child does not know at all. How old is the child now?
Should be two, Tuesday.
Two, yeah. They're pretty adaptable when they're that age, you know, they make themselves.
Here, I will state for the record, we are not in agreement with an eventuality of 50-50, but we are in agreement to initiate some parenting time and to see where it goes.
Well, you can be in agreement with whatever you want to, but the legislature has already established a presumption.
You understand the presumption.
You know, and so you'll have to overcome the presumption. How you feel about it won't do that, you know, and I would think that it probably won't happen like that immediately. But I'm a little, are there still threats lingering out there where you're gonna try to prosecute somebody in this?
The court made it pretty clear last time we were up here, the court wasn't interested in
I'm not
that.
interested.
And my folks,
This
as upset
baby,
as they've been, they heard
I'd
that.
like to see this baby. It's got a good looking mama and daddy, I can tell you that. And you got a lot of people that loves this baby. A lot of people love this baby, wants to love this baby. So this baby should be treated the way it is. It's a blessing.
I have a great idea. You live in Burkesville and Mr. Brittle lives in Burkesville. Let's just do the visitation at your home.
I'd be glad to. Yeah, I'd be glad to. And I might do it. I might just keep the baby myself, you know? Yeah, well, there's a lot hard to do. Like,
We'll
I understand the seriousness of your all's concern. And I'm not taking that lightly. Okay?
I'll just let him wait.
It's just this baby's a blessing and we're gonna start treating it as a blessing from here on out. Everything we do is gonna be for this baby, right? Okay, why don't y'all go back there and try to work it
I've
out.
got a couple other matters, but I will.
Okay. James Todd Wright.
Good afternoon.
Hello.
This is a indivisibility suit. I represent the petitioner. And we filed a motion to dismiss as his interest has been purchased by a couple of the defendants. I served everybody with notice of the motion. I've received, nobody's told me to object to the motion.
So the portion that you wanted to do, prosecute as him being indivisible, you've acquired now. So the clients have acquired the interest that you were going to
Yeah,
say was indivisible.
my client sold his interest, so he no longer has an interest.
So you're on the seller side.
I'm on the petitioner side, right? Correct?
But your client sold the property to the other parties.
Yes.
Okay, we'll just submit an order.
Okay, we did.
Electronically?
Yes.
Okay, well, that's signed.
Thank you.
Thank you very much. Spear versus Elmore.
Have you seen them, Scotty? I think they've been sick ever since we filed this vote. And Posey, there's criminal cases against Kim.
Well, no, wait just a second. You don't be talking to the clerk here.
Well, we
Put him in a bad situation. He might break out of custody. Okay, so your client is the biological father?
Yes.
Okay, and have there two children?
Yes.
Two children.
Yes.
And the other side does not have an attorney.
They have been served. I have heard nothing.
Do they have an attorney?
No, I have heard nothing from
I
anyone.
don't know why people don't want to answer the questions that I ask them.
Well, you know me, I like to embellish things as
I
much as I
do know
can.
you. I do.
And like Joel
Well,
Smith said,
let's get down to it. So.
Yeah.
Did they file an answer?
nothing's been filed.
Yeah, I mean, I looked and I didn't. And I'm also interested in. Yeah. Okay, what do you propose? What kind of order?
Well, Your Honor, here's the situation, and I was going to have Mr. York call over and retrieve a couple of criminal cases. The mother has got criminal charges.
I don't want to really have any hearing on this thing right now. What I want to do is, what do you propose?
We want the children. The Kimberly's not capable of taking care of them, and the grandmother's home is not fit for human habitation.
Okay, I read that in the.
And all you gotta do is drive by my house, look to your right, and you'll see. You've got them now. Okay.
Yes, the children.
So maybe we need about a week. Okay, who gave them to you? Debbie. Debbie brought them to you?
No, I had to come get them, but
okay,
they're with me.
Okay, so he's got them.
Kim's lost her. She don't have no right.
Well, there's already positive developments in this case.
That's a good thing. I've learned that today.
So you don't want to do anything now, right?
I'm sorry, he was talking.
You don't want to do anything now since he's got the children.
I think that we can get a temporary order giving him full custody and let's just let it ride.
Well, no, I'm not gonna, what I want to do is I want to do a temporary order since she did not appear today, giving him custody and give her 30 days to request a hearing.
Okay.
I'm not just gonna summarily like.
Fine. I understand.
Because I don't know what her circumstance is. But since he has the children and said that she should, let's say, the next rule day is on July the 2nd, that she should appear with counsel on July 2nd to give it, provide any reasons why the order should not be in full effect, okay?
Okay.
Okay.
Let me get my arms around this now. So we're going to get an order today.
She did not appear today.
Right.
There's a motion affidavit was filed that raised serious issues. She did not appear today. It was reported in court by the petitioner that he had control of the children, and I'm gonna let the children stay with him without visitation other than what he gives, and until she appears in court on July the 2nd with counsel, files an answer to the
Okay, if
make
you
any
choose
claim
to do.
contrary to this order. Okay?
I think that's fair.
Thank you.
Mr. Spears mentioned something about your child support. I'll put that on the docket for
Well,
the
I'm
second
not
because
too
we're
interested
not dealing
right
with
now in
that.
child support.
I understand. Wait
doubt
for
if
me
you
outside,
get-
Scott.
From what I hear, you can't get blood out of a turnip, so.
Well, that's true.
Okay, thank you very much.
Yeah, he's paying support.
His is suspended.
Okay.
His is suspended. I
Well,
thought
can I put
I
that
thought you were
order?
gonna ask if it or it's
Okay.
suspended
Wait for
until.
me outside.
Till we get, I thought we were gonna ask him to receive.
No, he's.
Okay, the next case is Bell versus Bell. Okay, there's been a withdrawal there.
Was withdrew the motion, right?
You know, that's kind of like.
Yeah, so we're trying to work things out.
Okay, thank you.
Finish it with the status quo.
Yeah.
You
If
have
we
withdrawn it and you accept the status.
would ask, I don't know how the court handles that, but typically, sometimes the
Do
court.
we already have a status quo in place?
That's all I'm asking.
Will the other side do an agreed order on status quo?
He's not retained an attorney yet. Trying to
Where you at?
work things out.
Joyce Dwayne Bell versus Sidney Martin Bell. Sidney Martin Bell here. Okay. Okay, you know what a status quo order is? Status quo order, I'll tell you what it is. It means different in your line of work than it is my line of work. Status quo order, both sides are directed not to say anything disparaging about the other party or allow anybody to say it in the press. That's what you want.
That's correct.
You'll agree to that, won't you? You won't say anything disparaging about the mother and she won't say anything about you.
Right.
And you go ahead and draft that, and he's been present, has no objection to it, and then y'all try to work out the use of marital residence between.
I think that there's some children in this, the status quo will apply to.
Okay, I thought there was a
Property,
child.
disposition of property.
Basically, they won't create any sell off any marital property or create any more loans.
Who's in the marital property again? Who is in the marital
I
property?
think they both are.
We both are in the trial.
Well, that's lovely. Well, let's just say that nobody will dispose of any assets that are in that, whether or not you think they be marital property or not marital property until we have some agreement.
Okay.
Because until, what I'm gonna do, until somebody proves me something in there is not marital property, everything in there is gonna be presumed to be marital property until we can trace it, okay? I thought there was a child involved too.
No.
There's so many of these, but okay, let's do it that way.
That maybe.
Yeah, okay.
I'll see her.
Okay, thank you very much. Don Hughes versus Donahue. It was the Monroe County case we did out of order. Is that it? That's it, except for the confidential document. Okay. Okay, where did Mr. Hooper go? He left. Gormley, is that in the Gormley or Pierce, or he's gonna submit the agreement? Is that in Gormley Pierce?
No,
Gormley Pierce.
That's the one that they're, that's Holly, you have, she hasn't been had that, it's just Holly.
Okay. So what, you have something else unresolved?
Gormley Pierce.
Okay, where is Holly?
She's back there with that one.
Okay, let's knock on the door and tell her it's showtime here.
Mr. Hooper was on the first.
Yeah.
He said they'd be doing.
Yeah, I knew, okay, thank you.
I wanted to put a first on something. Rather than something.
Okay, what are we at now?
Your Honor, this is our motion to modify the parenting conditions as set forth in our motion. You're not asking that parenting times be changed in any way or that anyone be held in contempt or anything of that nature. But there's been at least three recent incidents where the parents have come into contact with each other.
Yeah, I read it. And there was some
Places.
kind of method that you're gonna do with on again, off again sort of thing.
Mhm.
So
And,
what, y'all reaching accord on this? Or reaching-
No, Judge, at this time, we have not been able to. Mr. Bertram's proposed parenting plan is an effort to reduce contact. And we feel that contact is already reduced to an absolute minimum on our end. The parents come in contact one time, and that is at 6 p.m. on Sundays. I don't see how this can be any further reduced.
Okay.
I have a proposal for like this. I can tell you.
Well, let's tell me, right.
It basically, Your Honor, is it's kind of a new thing. They call it parallel parenting order for joint custody situations that involve high conflict and so forth. And basically.
How bad is the conflict?
Well, we've had the worst conflict was at school. He's been confronted in two different school events.
Is this the one where the child was in the hospital?
No, that's one of the
Yes,
incidents.
Judge, this child has been hospitalized in ICU.
Okay,
at
now,
University
yeah,
of Kentucky.
I read that. I read what it said in here. Now, explain to me where the stepmother fits into this thing at the hospital.
She really doesn't fit into it at all. The situation is this, the child, at one point in time while in the hospital, only two people could be allowed in the room at the same time.
Yeah.
And the mother wanted to stay in the room 24/7. The father wanted private time with his daughter in the room, not with the mother. 4. And he would step outside in the hallway and let her have private time, but she wouldn't step outside, no way, no how. And so when it moved from one room to a regular standard hospital room, she continued to do this. And then, he just wasn't comfortable. He wouldn't be allowed any private time with his daughter, and his wife was there, but it wasn't about making her be able to be there, it was him.
Judge, this is not essentially a time for private time. It was a life-saving measure time whenever this child had to undergo blood
I
transfusions.
understand what's happening. But anytime you got parents, in my experience, anytime you got parents, you have a child that has been in the presence of a step parent since an early age, there's always some angst about what role the step parent will play and what they're trying to replace the biological parent. It's natural. Believe me, I've experienced. I think a step parent's one of the toughest things you can do in life. It's really tough. But, step parents need to recognize that, if that's a problem, they don't need to exacerbate it. Now, I'll be glad to take some testimony on how bad these exchanges are, but right now, the only time they have to be around each other is by exchange, right?
Yes, Judge.
Now, when they communicate with each other, are they using this app that people can
Yes.
communicate
Yes,
on?
Judge.
And how's that working? Pretty well?
It seems to be the parties kind of weaponize it to a certain extent, Your Honor, and kind of use the details of the custody exchanges and so forth to kind of go back and forth at each other. And if it wasn't necessary, I wouldn't have filed the motion, Your Honor. It's like a conflict situation, especially with school events. It's causing kids to cry, people are cursing each other, and this is just attending a school.
Who's
event.
been doing the cursing?
The mother and the mother's
This
father.
mother here?
Yes.
Judge, it's my understanding of the situation is the mother and her family wanted to have photographs made with the child at the graduation. And the respondent father here was saying no, that
Because
the stepmother had to work,
had some
had to
kind of
leave.
conflict.
Yes.
Stepmother had a conflict.
The mother's father approached me.
Well, why, were you leaving early?
No, I just got there and I had my little girl because I was walking her in there.
Yeah.
And he'd come and approached me and had his nose to my nose, chest to chest, and he was cussing and.
Were you gonna have to leave early?
No.
Okay, you said that he was gonna have to leave.
Judge, that is my understanding. In a text that
We could have 10 minutes of photo time because the wife had to work and they were going to eat. We didn't get no photos.
Did you put that in text?
In the text, I
Did you
sent-
put that in text?
Yes.
Okay, so that's not cool. Not cool on something like that. Tell somebody that that's a significant event, that you give them 10 minutes because your wife's got to do something else.
This was after the event.
Yeah, this was 10 minutes after the event.
After the event is when photographs take place.
And that's when,
He left before the event.
But wait just a second. You see what I'm saying?
yeah.
Even if that's the reason you felt like you had to leave, I don't think I'd ever written it down. You know?
And that's why we utilize the parenting app, judges, so that no text can be removed.
Okay, well, here's what I'm gonna tell you. I don't think this thing has risen to the point now where y'all want me to intervene in this thing. But I will intervene. And if I take testimony, it sounds like to me, there's a little bit of poor judgment to spread around here. Okay? Stop it. Both of you stop it. If you don't stop it, I will stop. I'm interested in the child. I don't have any disinterest in the two of you. I hope both of you are happy. But if I find out that either one of you are doing things that are injurious to this child, you could end up with no visitation. Neither one of you want that, okay? So I just want you to step back and take a breather. I want you to go back there and sit down for a second and see what you can do to, if there's any exchange problems, see what you can do to resolve it. Now, I'm not dismissing what you say as not being valid or something, but I just don't think that we're at a point where I need to interject myself any deeply in this without the expectation that these people can conduct themselves like adults. Both of you have gone, are you in a different relationship now also?
No.
Well, you will be at some time probably, you know. He is in a different relationship. You gotta let it go. He's got a right to live his life with this new spouse or girlfriend or whatever she is. Are you married to him? Okay, excuse me, I didn't know that. I knew it, but I kind of forgot. So you can't let that bother you. You understand why? It's hard that somebody else is gonna be involved somewhat and help raising your child. But if she's good to the child, you ought to be thankful that she's good to the child, but she, you know, you need to be sensitive to the fact that your wife does not need to overstep her bounds. You understand what I'm saying? And child, when she gets older, will make her own decisions on who should be involved and who she trusts and who should be making the decisions. So I want y'all to go back there and see if there's anything you can reduce to writing, see if we can improve the situation before I have to get involved. And both of you are I hope are willing to make a commitment that you need to put this behind you, not think about what happened last week or 2 weeks ago or 3 weeks ago, but just start anew here, okay? Thank you. Okay, thank you all very much. Hey, is that it? Is that it? Okay. Well, let's go off the record till somebody else says they're Okay. Which case is
This
this?
is Tracy's case.
LD would be funded.
And Your Honor, I'm speaking to Ms. Gray here. She's living in Columbia and going to be part-time practicing in the area, I believe.
So
So
what now?
she's living in Columbia and going to be
All right.
part-time practicing. I told her we had a dearth of attorneys in Columbia, Ms. Capps, and very few in Liberty. So I said, there's an opportunity
You
for
gonna,
you.
you gonna move it in with somebody, you're gonna start out cold turkey?
I'm starting cold turkey because I have a full-time job with the state of Tennessee that I have to do for another 18 months.
So you're just gonna have a presence of,
Yeah, just working part-time.
yeah. Okay, well.
We've got this resolved. They're going to send me an agreed judgment, and she wants to pass it out to the August motion day, and that's fine with me. And that'll give us time to get her.
August 7th.
August 7th.
Okay,
Yeah,
that sounds
but
good.
I think we've got the whole thing.
Okay.
Is it August 7th at 1:30?
Yes.
I'd give you my business card if I had one on me, but I don't believe I do.
I just ordered mine. I'm
Well-
picking them up on the way back.
Well, it has business stuff.
Anyway, well, we can help you over this way, anything.
Is the contact
Okay, thank
information
y'all
we
very
have for you
much.
still good? All right, thank you.
Thank you very much.
Thank you.
On the outer side, if you take notes.
Okay, what else? Here we go.
Okay, because you do the one, okay? Your Honor, this would be graduated parenting time. Beginning this Saturday,
Okay, we need to state the case.
Claiborne v. Catherine.
What's the number on it, folks?
It's 25 CI 25.
Go ahead.
Beginning Saturday, June 21st, the petitioner, Marcus Riddle, would have visitation parenting time Saturdays at his home for a 5-hour period. When would it begin?
Well, we thought 12 to 5.
12 to 5. Transportation to be supplied for the temporary basis by Billy Catherine or by the respondents. And it would be conducted in Marcus Riddle's home. And we have been advised by Ms. White that there will be other people present at that time due to the tender years of the child. Correct?
We're not agreeing to put that in the order, but we will go ahead and tell you
I
there
know.
will be, his mom
Well,
or sister will be
well,
there.
Put that in order.
His mom
Mom
or
or
sister.
sister will be there.
And then Wednesday,
Not even slur on him, but I don't know if he knows anything about changing a diaper.
well, it makes us feel better if it's in the order.
It needs to be in order.
There'd also be visitation or parenting time each Wednesday from 5 to 7:30 at the home of Rick Riddle here in Albany. And Bill will take the child and just on a temporary basis. And we'll do this until the August motion day and we'll review it then if we can agree on something.
Mr. Riddle or his wife need to be there.
I'm sorry, Rick or his wife, yeah. And we'll review it in August. If we could extend it by agreement, we will. If not, we'll be back before the court. Is that fair enough?
What is the date in August?
7th.
What is the court date in August?
8/7.
7?
7.
Now, I know this is not what you want to do, but it's what we're agreeing to do at this point in time. Is that correct? Yes. You draft it, send it up to me, not as a have seen.
Thank y'all for working. We've got a difficult situation. We'll try to make it better.
I'll come back here. Just a step outside.
Okay, now, got it. So let's do one of these, which one is your case?
I have the honor about.
How long is yours gonna take?
Probably longer than, how long we make, or I won't be very long.
Okay.
I'm just gonna put on the statutory briefs. I'm gonna have to do it.
Is it Alcorn?
It's gone.
Now let's go out and call it Alcorn case.
Alcohol?
Alcorn, ALCORN, Alcorn.